We're now coming on to the next business. The clerk will now proceed to read the orders of the day.
Post Office, Horizon System, Offences Bill, second reading.
Now.
Minister to move second reading.
Mr. Deputy Speaker, I beg to move that the bill be now read a second time. I am pleased to present the Post Office Horizon System Offences Bill for second reading today. The bill will quash the convictions of those affected by the Post Office Horizon scandal in England and Wales, one of the greatest miscarriages of justice in our nation's history. This legislation will clear the names of sub-postmasters whose lives were ruined because of the Horizon scandal, those wrongly convicted of or cautioned for offences of false accounting, theft and fraud, all because of a faulty IT system the Post Office had implemented. Instead of listening to whistleblowers like Alan Bates when they raised concerns, the Post Office viciously pursued them for the shortfalls. Some were suspended or dismissed. Hundreds were prosecuted, convicted and imprisoned. Others were harried as thieves by their local communities, and several were driven to suicide. The government can't turn back the clock or undo the damage that's been done. But we will seek to right the wrongs of the past as best as we can by restoring people's good names and ensuring that those subject to this tragic miscarriage of justice receive fair and full redress. This bill represents a crucial step in delivering that. I give way.
Minister, for giving way. And the whole House does appreciate the efforts that are being made by the government to at last rectify this problem. But I appeal to the government to listen to the cross-party representations made from all sides in Northern Ireland, from all sides represented in this House, to all sides in Northern Ireland, including the First and Deputy First Ministers and the Justice Minister in Northern Ireland, who have appealed that the less than 30 people impacted by this in Northern Ireland, that they are at last included in this bill.
I thank the Honourable Member for his intervention. We are working very closely with the Northern Ireland Executive and the Government in Northern Ireland. We've carefully considered the territorial extent of each piece of legislation, and we are rigorous in our commitment to devolution, and he should be reassured about the amount of work that is taking place to make sure that we get this bill done properly in a way that is not going to have unintended consequences. But I thank him for the point which he has just made. This new legislation will quash all convictions which meet clear and objective conditions as laid out in the legislation. We recognise that postmasters have suffered too much for far too long, which is why convictions will be quashed automatically when the bill receives royal assent, removing the need for people to apply to have their conviction overturned. I'll give way to the Honourable Gentleman.
Extremely grateful to my right honourable friend for giving way, and I understand entirely why this bill is necessary. She will agree with me that it's very important that we do not, with it, set any precedent for the interference of this House in individual convictions unless there are exceptional circumstances such as these. That means this bill must be tightly drafted. So can I ask her, in relation to one of the conditions that she's mentioned, the last of them, condition E, it reads at the moment that at the time of the alleged offence, the Horizon system was being used for the purposes of the Post Office business. Can I simply ask why that isn't phrased differently to say that Horizon-based evidence was presented in the case against the person convicted? There is a material difference between those two things. I just seek to understand why she's chosen the formulation she has rather than the alternative.
I thank my right honourable friend for his intervention. He's referring to the final condition in the bill. He makes a good point, and it is something that we considered, but it would have likely required a case-by-case, file-by-file assessment of each prosecution, which would add a significant amount of time and complexity, which is what our solution avoids. One of the things that I have been very keen to emphasise is that speed and pace is critical. This has taken far longer than I would have wanted it to, and anything that would have impeded that and probably created complications, I have not gone down in terms of solutions. Yes.
Secretary of State for giving way, and let me put on record my thanks and commendation to the her honourable friend, the member for Thurston Moulton, for the way that he has approached the groundwork for this bill. Amongst those who are excluded from the scope of this bill are those who went to the Court of Appeal and lost their case, or were not given leave to appeal to the Court of Appeal. Now, what we now know would have been quite useful in many of those cases. So I wonder if she could reflect on whether we should be enlarging the scope of this bill to include those who did indeed lose their case at the Court of Appeal or were not given leave to appeal in the first place, because many of them may well be truly innocent.
I thank the Right Honourable Gentleman for his point. This is something that we also considered very carefully, and this is part of the trade-off that we had to make in terms of doing something that is unprecedented, Parliament overturning convictions. We respect the Court of Appeal's judgment. It has gone to an appellate judge. We are willing to look at some of those cases individually just to make sure that there isn't something that has been missed. But the way that the bill has been drafted has been done in consultation with the CPS, with the judiciary. We want to make sure that we're bringing everyone with us, and where concerns like the ones that he's raised have been made, this is more or less the consensus which we think is going to get the bill done as quickly as possible and find redress. Yes.
I thank the Secretary of State, and I'll elaborate on this further when I speak, hopefully if I catch the speaker's eye. But there is data around already about the cases that the Right Honourable Gentleman referred to, those that are outside the explicit Horizon case, but were attempting to get themselves exonerated on the basis of other data. And as far as I can see, they failed precisely because it was not the Horizon case. So I do ask her that before we come to report stage, she returns to this issue and looks to see whether we can solve that problem.
I thank my Right Honourable friend for that intervention. That is something that we can look at again at further stages of the bill. We understand the issue that honourable members are trying to resolve. We agree with them that we need to make sure that everybody who deserves justice gets justice, but we also have to be careful to make sure that we are not exonerating people who we know for a fact have actually committed crimes. Yes, I give way to my honourable friend.
I'm grateful to my Right Honourable friend for giving way, and also can I commend her work and the work of my Right Honourable friend for Thurston Moulton in not only recognising the plight of the people who have suffered here, putting in place a compensation for their suffering, but also ensuring that these criminal convictions are expunged from their record. This is really important for them, that they regain their standing within their communities. So many of these, as my Right Honourable friend rightly says, so many of these whistleblowers were failed by the current law, the Public Industry Disclosure Act. It's really vital that not only do we put that right, but that we have a good look at the law again. I know there's a framework review going on, and I've spoken to my honourable friend and my right honourable friend about what more can be done. I've got a bill going through, a whistleblowing bill going through, which will really sort this problem out. It lands within the Department of Business and Trade. It's something that is within her gift to do. Would she support my private member's bill on Friday?
I would like to thank my honourable friend for all the work that she does chairing the APPG on whistleblowing. She is right that this is an issue that needs consideration, and we are going to look again at the whistleblowing framework. It's something that comes up in many respects time and time again. I won't comment yet on her private member's bill because I haven't seen it, but I thank her for all the work that she does on this issue, and I give way to the honourable gentleman.
Giving way. I welcome this bill and know that it's groundbreaking and possibly set some nerves off with the judiciary. But personally, I think the judiciary need to look at themselves, how they actually dealt with some of these cases. Bringing up the point that my right honourable friend from Birmingham Hodge Hill raised, is there are a small number of these cases. Now, I understand perfectly why they're not within the scope of this bill, but we've got to get these cases looked at again because there is evidence that's come out at the Sir Win Williams inquiry which wasn't available at the time. So I think if you could give a commitment to at least sit down with the judiciary to look at these cases and emphasise the fact that there is new information and the fact that responsibility for some of this injustice has got to lie with the justice system.
I thank the Honourable Gentleman for his intervention. The courts dealt very swiftly with the cases before them, perhaps a bit too swiftly, which is why we saw so many miscarriages of justice, which the sub-postmaster suffered. And it is right that we make that exoneration as simple and quick as possible. So while my priority is doing this for the bulk of the people who have suffered, that doesn't mean that we will not be able to look at other scenarios later and see if we can find solutions where we genuinely believe that that there has been a miscarriage of justice. That is not for me to do at the dispatch box. It won't be up to ministers. There will be people, caseworkers, who are doing this, who will be carrying out this work. But we have to be careful to make sure that we are exonerating the right cohorts.
What the Minister says, Secretary of State says, but can I just say to her, there are a small number, they've got to be looked at, and can I ask her that she has the same zeal which her honourable friend for Erskine Malton's approach to this, because I think we just need a commitment not to get them sorted today, except you can't do that. The Secretary of State kind of, but if you could give some commitment to just the Department will look at these, I think that will send quite a strong message out to people.
The department can always do that. This is something which we believe is so critical in order to make sure that everybody gets the justice that they deserve, and we need to make sure that we carry out the process in such a way that everyone has confidence in it. So we can continue to look at cases and see if there are other solutions, but they will be, as he's rightly said, outside the scope of this bill. I give way to my right-hand defender.
I'm very grateful to the Secretary of State for giving way, and can I also pay tribute to the exceptional work of my honourable friend, the member for Thirsk and Malton, and the way which he's engaged in what is a sensitive issue, not least constitutionally. Would my right honourable friend accept that it is not ideal, under any circumstance, for this House to trespass upon the legitimate preserves of the independent courts? It should only do so under the most exceptional circumstances. There is a case that this is one of those. Perhaps we should also bear in mind we should be very wary of criticising, whilst we can legitimately criticise failings in the system, such as by disclosure, which is part of the criminal justice system, we should not get into the territory of impugning the individual decisions of judges made in good faith on the evidence properly before them. That's an important decision. Could I suggest perhaps one thing we could do to emphasise the exceptional nature of the bill will be to introduce a sunset clause, so that at an appropriate time, perhaps some way in the future, once those who need to be found and contacted have been able to come forward and have their convictions quashed, a bill which would have served its purpose would no longer be the constitutional anomaly that it might otherwise be, staying on the statute book indefinitely.
I'm very happy to consider a sunset clause. I think that he makes a very good point, and I really appreciate the fact that he can see the tightrope that we are walking in terms of getting justice for postmasters while not interfering with judicial independence, and I appreciate that. I give way to my right honourable friend.
I'm very grateful to my right honourable friend. I think it is important that we do emphasise the wholly exceptional nature of this legislation, but we are dealing with wholly exceptional circumstances, we hope. The point about disclosure is one that I cannot make strongly enough, and we have to look again at presumptions we make about machines and their produce when it comes to criminal litigation. Can I just press my right honourable friend to reiterate the wholly exceptional nature of this legislation? When it comes to a sunset clause, I do think we need to be careful, because we don't want to end up frustrating the purpose of this bill, which is to deal with the hundreds of people who have just lost faith in the system and who might be difficult to track down and identify. So I think we should be cautious about a sunset clause. I'm not particularly in favour of that, but I do think we need to emphasise the exceptional nature of this legislation.
Honourable friend for his intervention, and I'm very happy to emphasise that, and I will do so again later on in my speech. I do enjoy it when we have two lawyers who have a disagreement on a particular point. I will be taking this as applications to join the bill committee as well. I will make some progress, Mr. Deputy Speaker. The bill includes a duty on the government to take all reasonable steps to identify convictions that have been quashed. It also, I will give way in a moment, if I could just make some progress. It also creates a duty to notify the original convicting court so that records can be updated and people's good names can be restored. Other records, such as police records, will be amended in response. The bill makes provision for records of cautions for relevant offences relating to this scandal to be deleted. While the financial redress scheme will be open to applicants throughout the UK, the bill's measures to overturn convictions will apply to England and Wales only. Yes, I'll give way.
On the Select Committee, we heard absolutely harrowing accounts from postmasters of what they'd gone through as a consequence of the Post Office's actions. But many of these took place many, many years ago. Can she be confident that the process of audit in future in an organisation such as the Post Office will identify what has happened at an earlier stage? And is she happy that legislation such as this should never come before this House ever again? This should not happen.
I believe this is something that the inquiry is actually looking at currently, the one that's being led by Sir Wyn Williams. It is important that the audit processes are working at the highest level and people are able to rely on them and have confidence in them. So I thank him for raising that point. On the point about territorial, on the point about, sorry? Okay. On this point about territorial coverage, as I said to the Honourable Gentleman earlier, my department will continue working closely with the Northern Ireland Executive and the Scottish Government to support their approaches to addressing the scandal, ensuring that every postmaster who has been affected, irrespective of where they are in the United Kingdom, receives the justice they deserve. And indeed, my colleague, the Minister for Postal Affairs, has already met Justice Ministers in the Scottish Government and Northern Ireland Executive to offer our support. I give way.
Secretary of State for giving way, and I respect that the Department are very keen to respect the devolved settlements in both Northern Ireland and Scotland, but can I stress to her that there is a political consensus in Northern Ireland and that ministers in the newly restored executive would welcome Parliament acting in this particular area. Due to the nature of devolution in Northern Ireland, we have to do a public consultation. So that under the best case scenario, we're looking to well into towards the end of this year before we can replicate legislation here in Westminster. And as this was a national scandal, it does require a national solution to avoid a situation of inequity, whereas some postmasters in parts of the UK are exonerated while others are still waiting.
I take the point that he makes very seriously. We do understand, but we want to make sure that we don't create any possible unintended consequences by legislating around devolved issues. So we're working hand in glove with the Northern Ireland Executive to make sure this can go as quickly as possible. We know that the numbers are much smaller, and I believe that the postmasters there have been identified. So he is right to raise this point, but I wanted to reassure him that we have every confidence that this is something which we will be able to get done at the same pace. Yes, I'll give it.
Very grateful to the Secretary of State. Could I maybe put the question in a slightly different way? Her Honourable Friend the Minister has set out an ambitious timetable for the passage of this law, the overturning of the convictions and the dispensation of compensation, possibly all done and dusted with hope and a following wind by the end of July. Could a similar timetable actually be a timetable she could commit to when it comes to the cases that are raised in Northern Ireland?
It is certainly something that we can encourage the Executive to work to. I personally cannot make that commitment. It wouldn't solely be up to me. But I just want to reassure the House that this is something that we care about. We're not prioritising England and Wales because it's England and Wales. We're doing what we can as quickly as we possibly can, and to make sure that we don't create problems for later by rushing and not doing things properly. So I think that is a good, ambitious target, but it wouldn't be up to me to make that commitment. Mr. Deputy Speaker, I am aware that the approach we are taking in this bill is a novel one, and with it, Parliament is taking a function usually reserved for the independent judiciary, as my right honourable friends, my right honourable and learned friends have made. But I am equally aware that the postmaster's long and punishing fight for justice must now be swiftly drawn to a close. The circumstances surrounding the scandal are wholly exceptional and they demand an exceptional response from government. So I would like to take this opportunity to reassure the House that the introduction of this bill is in no way a reflection on the courts and judiciary who have dealt swiftly with the cases before them. I give way to my honourable friend.
I'm very grateful to the Secretary of State for giving way, and I'd like to commend both her and her team for bringing this forward. The sub-postmasters have faced a miscarriage of justice which has taken many people's breath away. I'm aware that this is specific and focused legislation, but is she aware that 2 constituents in South Ribble came to see me who had been Royal Mail customers and were describing very similar scenarios in terms of prosecutorial practice that the sub-postmasters were subject to? And would she perhaps consider expanding the scope of this to other people that may have been subject to poor treatment in the future?
I thank my honourable friend for her intervention. I can take a look specifically at the case that she raises. I think they might actually be covered by this bill. I would be wary of expanding the scope too broadly. The consensus that we have from CPS, from the judiciary and so on, has been achieved by being very, very tightly scoped in what the legislation is doing. But we do want to make sure that people who have been at the end of injustice can have those wrongs righted. So I'm very happy to look at the specific cases of her constituents. Yes, I give way.
I'm very grateful indeed. I'm very clear that this bill is about correcting convictions that were made in error. But there are, of course, a number of employees, direct employees, that worked for the Post Office that were never convicted, but had their good name ruined, their careers destroyed, and have found it very, very difficult to gain employment because they were unable to get references from their previous employer. And indeed, probably the worst thing that happened to them is that in their communities, they've been identified as people that were perhaps stealing from pensioners or treating members of their community unfairly. This bill will do nothing for them. Could she outline what the Post Office is doing to contact those individuals that were disciplined by the Post Office and dismissed so that they too can have justice?
I thank my honourable friend for that question. He is right that many people had their reputations traduced because of what happened by the Horizon scandal. And where there have been shortfalls, for example, falsely made by the Post Office, which they had to pay, we have compensation schemes that are there to address those sorts of wrongs. But because this bill is specifically about overturning convictions, I know that this is something which will not be able to apply to them. But where they have suffered other damage, we do have compensation schemes which we hope will apply in those circumstances. Mr. Deputy Speaker, we have not taken to the decision to legislate in this way lightly. Given the factually exceptional circumstances of the Horizon scandal, the number of postmasters involved, and the passage of time since the original convictions, it is right that the state now acts as quickly as possible. Any further delay would be adding further insult to injury for postmasters who have already endured what I believe is an arduous wait. Indeed, some have lost trust in the system and want no further engagement, and in many cases, the evidence they would need to clear their names no longer exists. But I must make 2 points clear to the House. First, it is that the government's position is that it will be Parliament and not the government that is overturning the convictions. So there will be no intrusion by the executive into the proper role of the judiciary. And second, this legislation does not set any kind of precedent for the future. It recognises that an extraordinary response has been necessitated by an extraordinary miscarriage of justice. Upon this legislation receiving royal assent, no further action is required by the victims of this scandal in order to have their convictions squashed. The government will take all reasonable steps to notify the relevant individuals and direct them to the route for applying for compensation. Further details of this process will be set out in due course. Yes.
The Secretary of State has been characteristically generous. So the evidence that the Select Committee heard was that many people who were seeking compensation for the injustice they suffered found it very complicated and very confusing to understand the range of case law that was required in order to put in particular kinds of claims. So, for example, for loss of reputation. When she triggers that notification set of clauses in the bill, would she reflect on something she could add to that, which is a tariff to help people put in claims for the right kind of compensation? Because what none of us would want to do now, having overturned the convictions, is to then let people get shortchanged on the compensation. Providing that standardised tariff could cut through so much of the complexity and help people get what they're due.
I thank the Right Honourable Gentleman. I know that this is a recommendation from his report. It is something that we are actively looking at and considering. As the bill progresses through the House, there will be many suggestions which we will be able to look at and see if it can be improved in any way. But we must make sure that we do so in such a way that it doesn't jeopardise any of the objectives of the bill, any of them at all. So the government, as I was saying, the government will take all reasonable steps to notify the relevant individuals and direct them to the route for applying for compensation. Further details will be set out in due course, and there will be a process for anyone to come forward where their convictions meet the criteria or where we've been unable to identify them. The new primary legislation will be followed by a route to rapid financial redress on a similar basis to the overturned conviction scheme, which is currently administered by the Post Office. So we do not need provisions in the bill to deliver that scheme. My department, and not the Post Office, will be responsible for the delivery of redress related to the quashing of these convictions. The Minister for Postal Affairs will return to the House at a later date to provide details on how we intend to deliver that redress. It goes without saying, Mr. Deputy Speaker. Yes, sure.
I welcome the changes that have been made in the compensation. I think some of the proposals, for example, on the fixed sums, are going to make a lot of cases very easier to sort out. I don't feel comfortable having the post anywhere near this, frankly, and neither do the sub-postmasters. So I would ask if she could think about a system of compensation which perhaps cuts out the Post Office, because there's no trust there amongst these sub-postmasters. And frankly, do I have any faith personally in the Post Office? No, I don't.
I thank the Honourable Gentleman. This is one of the reasons why it's my department that's going to be looking after the redress that's being delivered by this scheme. Yes.
I was just going to reinforce the point made by the Honourable Gentleman, or Right Honourable Gentleman, because there are cases now writing to me this week about the current handling of their cases by the Post Office and the Post Office lawyers, which is frankly barbaric. They need to be taken out of it.
I'd like to reassure my right honourable friend that this is something that I am looking at in great detail. The Post Office has clearly been an organisation that has been dysfunctional for a very long time, and this is one of the reasons why I've been actively taking steps to look at the management and actually the processes which are in place, which, to be quite frank, and which he rightly says, many of the sub-postmasters have lost faith in. And it goes without saying, Mr. Deputy Speaker, that work to offer prompt financial redress alongside this bill continues. As of the 1st of March, 102 convictions had been overturned through the courts. Of these 102 cases, 45 people had claimed full and final redress, of which 35 had reached settlement. And the Post Office has paid out financial redress totalling £38 million to postmasters with overturned convictions. Under the Horizon Shortfall Scheme, again as of the 1st of March, 2,864 eligible claims had been submitted, the vast majority of which had been settled by the Post Office. £102 million has been paid out in financial redress, including full and final settlements and interim payments. Finally, under the Group Litigation Order Scheme, working from the same date, 132 claims had been submitted and 110 claims had been settled by my department. £34 million has been paid out in financial redress, including full and final settlements and interim payments. Officials in my department are working hard to get these cases settled quickly, and we've made offers within 40 working days in response to 87% of complete claims. So, in summary, Mr. Deputy Speaker, this bill amounts to an exceptional response to a scandal which was wholly exceptional in nature, a scandal which has shaken the nation's faith in the core principles of fairness which underpin our legal system. We recognise the constitutional sensitivity and unprecedented nature of this legislation, but I believe that it is essential for us to rise to the scale of the challenge. The hundreds of postmasters caught up in this scandal deserve nothing less. Of course, no amount of legislation can fully restore what the Post Office so cruelly took from them. But I hope this legislation at least begins to offer the closure and justice postmasters have so bravely campaigned for over many years, and that it affords them the ability to rebuild their lives. For this reason, Mr. Deputy Speaker, I commend the bill to the House.
Yeah. The question is that the bill be now read a second time. Jonathan Reynolds.
Thank you, Mr. Deputy Speaker. I am pleased to be at the dispatch box today to welcome this bill. In doing so, I candidly recognise the difficult legal and constitutional position it represents. But I will outline why I believe it is required and the exceptional nature and caveats we should all recognise at this second reading. Mr. Deputy Speaker, the Horizon scandal is quite simply one of the most egregious miscarriages of justice in British history. Something that robbed people of their lives, their liberty and their livelihoods. As we now know, driven by a misguided belief that technology was infallible and workers dishonest, the Post Office prosecuted innocent people. These were the very people the Post Office should have had the most faith in, those who delivered vital services in all of our communities. Those prosecutions caused unimaginable pain and suffering, which no amount of compensation can ever alleviate. But to add insult to injury, the journey to justice for those sub-postmasters has been mired in a great many delays and barriers. And we know some of the people affected have tragically passed away before ever having had the chance to see justice. So this bill today, freeing hundreds of innocent people of their wrongful convictions, affords us the chance to make a huge stride in righting the wrongs of the past. And that's why Labour will give it our support. However, this must just be one of several steps still to come if amends are ever to be made for this most insidious of injustices. The convictions must be overturned, compensation must be delivered at pace, and justice must be sought from the independent inquiry. And we must recognise today for what it is, a victory for the sub-postmasters. To have the strength of character, to lose everything, and then to get back up and fight is truly humbling. And the recognition and the admiration these people have earned is absolutely right. Nevertheless, members across the House will be acutely aware of the unprecedented nature of this legislative action. We all recognise that we shouldn't have needed to have had to got to this point. So it is important today in this debate to explain why we are taking this step, why we believe this is an exceptional case, and why, therefore, this should never be repeated in future. And I hope in this speech to do that. Mr. Deputy Speaker, I would also like to begin my remarks today by recognising the work of the many people who have gotten us to this landmark occasion. Firstly, I don't think any member could deny that we would not be here today pursuing this particular route if it hadn't been for the recent ITV drama, Mr. Bates versus the Post Office. While the Horizon Post Office failure is a scandal to which this House has been responding for some time, the drama brought the story to a wider audience and it reinvigorated the campaign. It is a powerful reminder of the way that art and culture can be used to tackle injustice and to raise public awareness. And I would like to thank everyone who was involved in that project, including my own constituent, Julie Hesmondhouse. Secondly, I want to pay tribute to the Right Honourable Member, my right honourable friend for North Durham, as well as Lord Badenoch in the other place, and all of those colleagues who championed constituency cases from the beginning, because their tireless campaigning has been instrumental to getting us to today. And thirdly, I want to recognise the attention that the Postal Affairs Minister has given this matter and the progress he has been able to achieve so far. And I'd like to thank him for working cross-party on the design of this legislation and for keeping myself and the member for Birmingham Ladywood regularly updated. Alongside that, I do just notice the member for Sutton and Cheam in his place. I also believe he was the one to get first to grips with the scandal in the way that was required. And as he is leaving this place in the coming months, I hope he will take a sense of pride from the work he has done on that and thank him very much for that. However, today must be a moment where, above all else, the credit and recognition goes to the sub-postmasters and their courageous search for justice. They have been unrelenting and undeterred, and we owe them a great deal. To be jailed or bankrupted because of faulty IT and have no one believe your character mattered more than numbers on a spreadsheet is why this scandal has struck such a nerve with the public. And without the bravery of the sub-postmasters, we might never have known this injustice took place. It's worth taking a moment, I think, just to reflect on that. Mr. Deputy Speaker, the bill before us will overturn 690 cases that were prosecuted by the Post Office and the CPS. And we all know that this bill today is a vital step forward in the course for justice for them. But we also all recognise that doing this undermines one of the fundamental principles of our democracy, which is the separation of the judiciary and the legislature. And overruling the courts like this could set an incredibly dangerous precedent, and one which I hope we will never use again. In an era of ever-creeping populism, there is a real threat that the well-intentioned actions we take today could be abused in future for completely unwarranted purposes. Of course, I'll give way on that point.
Can I concur with his statement in terms of the separation of powers? But does he also agree with me that it is time for the courts and the judicial system to reflect on their role in this scandal and why they didn't, raise red flags when they should have done? And frankly, knowing some of the cases I do, when the Right Honourable for Bromley said not to criticise individual judges, some of them acted in a way that, frankly, did not reflect the best of our judiciary.
I think that's a powerful contribution from my honourable friend, and I think there are many things that go beyond the legislation and the independent inquiry that we're looking at today and at the moment that reflect not just the role and the experience our constituents have had in the legal system. I think also how government functions, how executive agencies function, the evidence that's given to ministers and the accountability that we seek from them. And a great deal has to change and come out of this, and I understand the point that he's making. I'll give way to the honourable member as well. Thank you.
And he's being very generous with his time. Would he agree also that it's not only a look at how lawyers have handled this, but more importantly, the people who produced the evidence in the first place to persuade prosecutions? And I hope very much that he will agree with me that lessons need to be learnt by the people who just blindly said these people are probably guilty and built up a case around it. And as we are finding, that isn't the case.
Powerful points from my honourable member, and I think that doesn't just reflect the nature of the evidence that was given. I think one of his honourable friends has already made the point about the role of technological, computer-based evidence in the legal process. Also, to be frank, the approach of the Post Office in terms of the data as they saw it and what they clearly believed to be, I assume to be a way to unveil wrongdoing rather than questioning. A lot of people, I think most of our constituents ask how could we go from 5 or 6 convictions a year to 50 or 60 without that being raised in some way, and yet clearly the powers that be at the time thought that was revealing wrongdoing rather than necessarily revealing something going wrong. But Mr. Deputy Speaker, I think we can see from the contributions we've already had that all members who are participating in today's debate and who will participate in the bill's future stages are mindful that what they are saying and what we are saying here today is not only very important, but it might be referenced in future considerations. So in that vein, let me clearly state that while far from ideal, I do believe this legislation to be the only option on the table for us for resolving this horrible injustice. But let me further state that any incoming Labour government would never use this kind of action again. There are very exceptional circumstances to this case that make it unique, rather than at a moment to set a precedent for handling any future injustices. The Post Office Horizon scandal took place over decades, and there is at least a decade's worth of investigations that demonstrate the falsehoods behind many of the convictions made against sub-postmasters. Now, that is a bank of evidence that will only grow from the independent inquiry led by Sir Wyn Williams. The challenge to righting this wrong, therefore, is not a lack of clear evidence, but a sheer volume of cases that is overwhelming the appropriate route to justice through the Court of Appeal. Now, I do lament that our justice system is under such strain, and it would be remiss of me to not point out that perhaps a better serviced Criminal Cases Review Commission could have maybe avoided the extraordinary step we must now take. In addition, we must also recognise that there are a cohort, however, of sub-postmasters with convictions who quite understandably are reticent to take part in another process in a criminal justice system that so badly failed them the first time around. So for the purposes of historical record, I believe that a very important qualification for taking this step is the scale of the cross-party support this legislation is attracting today. Now, this is a point I've raised with the Minister before, and I do believe this to be an essential safeguard. Of course I'll give way to the Minister.
I'm very good.
Can I thank him for the cross-party approach he's taken, the collaborative approach. Really has stepped us forward significantly. And I recognise the points he makes in terms of the scale of the problem here, which is why we have to act in this way, which is probably the least worst option in terms of how we deal with this. Can I just push back gently a little bit in terms of his point that was raised that we've only started to act significantly since the TV drama? Of course, we welcome the public outcry that's come as a result of that drama, the new attention that's been focused on this issue, and the 1,200 new claimants that have stepped forward. We welcome all those things. Just push back, because I think it's important that public out there know we were acting prior to this. We did implement the shortfall scheme back in 2020. We implemented the inquiry back in 2020, GLO scheme in 2021, the Rising Compensation Advisory Board we put in place early in 2023, the fixed sum awards of £600,000 of autumn of last year, the overturned convictions, exploring of different ways we could do this on a mass basis. All these things were in play. The compensation bill in December last year that we both spoke in, I think. So much work has been undertaken, but nevertheless, we very much welcome the new impetus that we've all got from the attention that the drama series has brought about.
Mr Deputy Speaker, I'm always keen to hear from the Minister. I thought I was very fair in pointing that out in the introductory remarks. I simply make the point that the nature of a piece of legislation like this, the constitutional significance of a piece of legislation like this, requires a level of public consent. And I don't think the statement the Prime Minister made in January, just after Prime Minister's questions, would have been possible without the sheer breakthrough in that public consent and demand for change, demand for justice that had come through that. But I do always be fair to the government's ministers, and I do point out, even to some of their critics, that of course we had the legislation that colleagues had worked on. There was less interest certainly in some of that in the chamber before we had the television programme. It is fair to say, but I do point that out. But we had the impasse, let's be frank, we had the impasse of people not wanting to go back to the process of, I think the estimate we had at the time was 10 to 15 years before, and that is what's brought us to that. And I think we've got to recognise that, as well as also paying tribute to that role that arts and culture can play in bringing it to that audience, and that is something I think we should welcome. Mr Deputy Speaker, finally, I do want to make clear, and I think I speak for everyone in the chamber today when I say, in no way does anyone take what we're proposing to do today lightly. This action is unprecedented, and we should make every effort possible to ensure it never has to be considered again in future. Now, of course, I'll give way to the member.
The point that was raised with the Secretary of State, I mean, this is not quite a total first precedent on this. I mean, there have been cases relating to people who were shot in the First World War for cowardice and them being exonerated after the event and so on. So does he agree with the notion that we should put a sunset clause on this to make sure it is no precedent for anything?
I'm grateful to him for his contribution. I think when you look at the precedents, it is interesting to look at there is clearly a legal difference between quashing a conviction and a pardon, after an event has taken place, which is usually more of the precedent that we are familiar with. I'm receptive to what colleagues are saying from a judicial point of view, from a safeguarding point of view, about a sunset clause. Clearly, we want to capture as many people as possible that are deserving of this quashing of their convictions. I'm sure when we get to the report stage, the committee stage, which I assume will be on the floor of the whole House, there'll be an attempt, I think, to do that, and I'll give way to the honourable member.
I'm grateful to the Shadow Minister for giving way. Is not the point about a sunset clause this? None of us knows what is around the corner, what the future is going to hold. And it is eminently possible that once this legislation has expired, that the law of sod dictates that somebody somewhere will come up with a case that requires to be dealt with. It really would serve no useful purpose other than smoothing a few ruffled judicial legal feathers.
I can hear what the honourable member is saying. We don't want to commit the committee stage at this stage at second reading, but I think there is necessarily. I think what we're hearing here is the necessity of ensuring that if there are, and there will be, cases that fall beyond the specific circumstances, and to be fair to the government, I can understand why the drafting of this legislation has had to address this particular cohort in this way for the simplicity and straightforwardness of doing so. There will be a need to make sure other cases can still be identified. Now, on the numbers, some of that I think could be done in that way. But as I say, I think we'll have time to explore this at this stage. Now, I'll give way to them for North Antrim.
On the issue of consent, and he's absolutely right to point out that all sides of the House have consented to this, and that's what makes law change flow much easier. There's been a lot of goodwill expressed about Northern Ireland and about increasing the territorial extent of this matter. But of course that goodwill doesn't, as someone else in this House often says, doesn't butter the parsnips. The fact of the matter is we need to make sure that Northern Ireland is ultimately included in this. And I would appeal to the opposition spokesman that to support, if a motion were to come forward to instruct the House to extend this bill to cover Northern Ireland, would the opposition support such a motion so that those fine words and goodwill are turned into strong action?
Grateful to the honourable member for that contribution. I'm going to say something specifically about the territorial extent of the bill. The straightforward answer is yes. I think there are circumstances here that we should listen to. I hope he won't mind me saying when all the political parties in Northern Ireland are in agreement on something, it is usually worth listening and understanding why that might be the case. But I'll address specifically how we might deal with that in a later part of these remarks. But of course, I can wait to my select committee, Chair.
Very, very grateful to the Shadow Secretary of State who's made a brilliant speech this afternoon. Would he agree that we might want to reflect on measures to de-risk the speed of actually paying compensation? Because it's important that we overturn convictions, but it is also right that we accelerate compensation too. And just because the department is running the scheme is not necessarily a guarantee that payments will flow quickly. The Select Committee has crunched the data on the GLO scheme this morning, and unfortunately it would appear that on the GLO scheme 14% of offers have taken over 14 days, 4% have taken over 80 days, and 2% have taken over 100 days. So we obviously need to get the measures right, and there are lots of issues at play, but de-risking the speed of compensation probably sounds like something that we should reflect on.
Well, I thank him very much for that and for all the work the Select Committee has been able to do to assist this process. I think he's absolutely right to say the passing of this bill is one thing, but what everyone wants to see is that as the route to speedy compensation as soon as possible. I do, again, welcome some of the changes we've seen where we have the option, for instance, the £600,000 upfront payment that is available to people as a way of getting through some of the complexity of the cases. And I know when the Select Committee published its report, it looked at the recommendation that, including in the bill, we could possibly look at deadlines for the government to pay the compensation. I think we've since had some quite useful information that we all share a concern that any binding limits might actually limit some of the most complex cases in a way that none of us would want to see. So look, I would therefore, just one moment, I would therefore say I think perhaps the right way forward, I don't know whether the Postal Affairs Minister could say something in his closing remarks, perhaps an undertaking about how the government might be able to do that, to reflect on this point that everyone here will want to be able to say we care and have pushed forward the need for compensation payments to flow smoothly. I'll give way again to my honourable friend.
Yeah, I've got to say to the Shadow Minister, my good friend, is that this is where I depart with the Select Committee, because the Advisory Board has been very clear that what we need to do is make the system simple and fair to the government. They have listened in terms of the lump sum payments, and what we need to try and do is try and get those, say, simple cases, they are out of the system, to concentrate on some of those complex cases. Having known the nature of some of those cases, they are going to be complex, and that's not just, I think, the government saying that or the Advisory Board. If you talk to some of the lawyers that have put in cases in, there's a lot of work to be done on those cases. They're not straightforward, they will take time, and if you put an arbitrary deadline on them, I think that will perhaps lead to those cases not being properly addressed, because some of these cases be larger than 600,000, for example. So I think, although it's perhaps a good idea to try and speed it up, I think some of the steps have already been taken by the government will speed the system up.
I thank him for that, and the work the advisory committee has done on all of this has been extremely invaluable, and it is very much appreciated. I think, as I say, we all accept the point that for a number of the cases who I think we all envisage may see compensation payments well in excess of the £600,000 because of the scale of the loss and the complexity, no one would want or seek to do anything that would prevent those concluding in the way that is necessary. And I simply ask the Minister, when he responds, to maybe reflect on how the government can give assurances on the best way to do that. Furthermore, I just also want to come back to the issue from colleagues from Northern Ireland about the territorial extent of the provisions of this bill and the desire to overturn the convictions of what is a very small number of affected sub-postmasters, significant but small number of sub-postmasters in Northern Ireland who would obviously otherwise fall beyond the scope of this legislation. I can tell colleagues the Labour Party does support those calls. I understand this would be a complex constitutional undertaking, but as I say, given every party in Northern Ireland and every minister, I believe, in the new Assembly are calling for the inclusion in this bill, I think we have to recognise that, and I'll just give way to my colleague from Scotland.
Very grateful to the Shadow Minister for giving way that also the Scottish Government has asked, specifically, because it's an unusual case, the Scottish Government has asked that this legislation also takes in Scotland. I understand the Labour Party supports that position too. We've not really heard any rational reason as to why Scotland and Northern Ireland are being excluded from this bill, have we?
My honourable friend won't mind me slightly teasing him for a call for unionism from the Scottish National Party, but I think he will understand. Just on this issue. The issue I understand is the Scottish judiciary do not support inclusion. Members will be able to speak. I can't speak for every part of the judiciary in the UK, but I believe that is the issue. Of course, the nature of the very almost distinct legal system in Scotland is a key part of that, whereas in Northern Ireland I think is slightly more complicated. Of course, I'll give way to...
I fear, in fact, the issue is not so much with the Scottish judiciary as with the prosecuting authorities, given the remarks that are already on the record from the Lord Advocate. If I may offer to the Honourable Gentleman for Glasgow South, through the Shadow Minister, a rational reason, it is about political accountability. The lines of political accountability lie through the Scottish Parliament and through Crown Office. There are good and compelling reasons about delay as to why we might make an exception for Northern Ireland, particularly in relation to the requirement for a full public consultation. These arguments do not apply in Scotland.
I hear what the Honourable Member is saying. I do think, in terms of what I foresee as being possible, I do think it is reasonable to see the extent extended to Northern Ireland in a way I don't think, given the position of a lot of colleagues in Scotland, extension to Scotland without the Scottish Parliament and the Scottish Judiciary wanting to be part of that is the thing. I'll give way to the Honourable Member.
I thank the Honourable Member for giving way, and he's making a very powerful speech, and the most powerful part of your speech I thought was whenever you referred to, or when the Honourable Member referred to the sub-postmasters and the impact that this has had on their lives. The 28 or so in Northern Ireland have experienced the same turmoil as those here in GB, and we really thank the Shadow Secretary of State for his endorsement of including Northern Ireland in the legislation, and we would make that further call today that is done. So, thank you.
Grateful to the Honourable Member for those words. I know colleagues from Northern Ireland are keen to possibly bring a motion or an amendment in order to be able to do so. I just wonder if I could ask government ministers to maybe reflect on the scale of the political support that we have seen, that we are seeing, and maybe take this issue away for further consideration before we do get to the committee stage, so that the justice can be brought to those, I believe, 27 sub-postmasters in Northern Ireland. Mr Deputy Speaker, I want to conclude by saying, for many people who watched the ITV adaptation of the Horizon scandal in January, it will have been hard to believe that the ongoing tragedy was not a work of fiction. So egregious and pernicious have the impacts been on people's lives. But it was not a TV show. It is very real, and of course it has had very real-world impacts. And lessons must be learned, and justice must be served. In the weeks after the drama, I believe attention sadly had to be turned away from the sub-postmasters and their needs, and the conversation became much more about the soap opera that has been seemingly ongoing with the management of the post office. But addressing that, whilst clearly demanding serious attention, should not take away from the priority today of providing the sub-postmasters with justice. So it is welcome that we have returned to this core issue today, and that is why Labour will support today's legislation. It is right that innocent people have their convictions overturned, not just so they can begin to turn the page on this scandal, but so we can ensure that it leads to the quick access to compensation everybody rightly deserves. Not every story here will finish with a happy ending. Some people, as we know, did not live to see today, and others have lost so much their lives will never be able to be put right. But the actions we can take here today, in this place, can now go at least some way to ensuring that the next chapter written in this story of the sub-postmasters will be their own and based on the principles of justice and fair treatment that everyone so obviously wants to see. Thank you very much, Mr. Deputy Speaker.
Sir David Davis.
Thank you very much, Mr. Deputy Speaker. I hope the Secretary of State will not take it amiss and understand I made no criticism of her or her Minister of State or indeed her Minister of State's predecessor when I say that this bill represents the best of a bad job. There's a difficult, and everybody said it already, a difficult trade-off between natural justice and a fast and low-stress solution for the postmasters, and that's what this bill is attempting to achieve. That being said, it's not the way I would have done it. It's not what I would have proposed. The courts should and could have considered all the cases in which the convictions were based on Horizon evidence in one set of proceedings. It would have been perfectly possible to take, and I took advice on this, I took quite senior legal advice on this, it would have been perfectly possible to take 3 or more former Supreme Court justices out of retirement, give them a courtroom and task them to deal with this in 3 months. They could have bracketed very similar cases together, there would have been hundreds in those categories, and then they could have focused on the ones which were really difficult. Regrettably, it's rumoured that the judiciary themselves rebuffed this course of action, which I have to say I think they were unwise and plain wrong to do. As the Right Honourable Gentleman, member for Durham North, pointed out, they have a responsibility in this too. So even so, so that's why we've gone the route we've gone, and I have every sympathy with the government ministers in what they're trying to do here. Even so, the bill as it stands still risks lumping genuinely innocent majority with a very, very small, potentially guilty minority of this. Each of the difficult cases could have been dealt with on the individual merits rather than abandoning due process in the rush to bring this disgraceful episode to a close. Now, we got into this situation by failing to follow proper processes, and I'm wary that the government is again, almost by default, failing to follow proper processes to extricate itself from this historic mess. Nevertheless, despite my misgivings, I won't stand in the way of this, because it will serve the vast majority of postmasters and securing justice for them, and for that reason I will support the bill. However, it's not to say the legislation won't continue to create problems of its own. And I recommend to the whole House that before we get to the report stage, they look and read some of the early reports from 2013. Now, I've got one here, the Detica report written by BAE Systems, and I think everybody should read that, because it's a 6-month review of the 2013 Post Office's fraud and non-compliance issues. It paints a picture of complete chaos in the accounting systems of the Post Office. Yeah. Not just Horizon, all of the accounting systems. Over a decade ago, they knew, and I quote, "Post Office systems are not fit for purpose in a modern retail and financial environment." Note the word systems, plural, not just Horizon. And they then go on to say, ATM accounting, cash point accounting, for example, was clearly flawed. The study states that, quotes, "removing ATMs reduces the risk of SPMR being suspended." By SPMR they mean sub-postmasters, and by suspended I'm afraid they mean persecuted, because that was the outcome. And that wasn't Horizon related. Now, why does that matter? Because dozens have come forward raising concerns over a second eye system used by the Post Office called Capture. Again, documents show that Capture was known by the Post Office to have issues early on. One has to say the culture of denial over the decades in the Post Office is really, truly extraordinary. And this bill will exclude people who have already had their appeal cases heard and rejected. Now, these rejections may well have occurred because the evidence that the appeals were based on was not Horizon evidence, but something else, some other failure of the accounting systems. And so I think we have to be very careful when we pass this bill, not to give up at this point, but to look and see that we can also absolve people who are not guilty because of the wholesale chaos that existed inside this department. I give way to probably the best informed man in the House on this matter.
Right honourable members make a very good point. The Post Office main accounts would have had debtors saying they were owed money.
Could the honourable member face, please, the chamber, because the difficulty of picking up his voice. For hands.
My apologies. The honourable members make a very good point. The Post Office main accounts would have had debtors which said that these innocent sub-postmasters owed the corporate accounts of the Post Office what we now know is tens of millions of pounds. But of course they were wrong. They were fictitious. They weren't owed that money. So the point I'm trying to make is, will we ever get to the bottom and restate the Post Office's accounts throughout the 2010 periods, which must have been materially wrong year after year?
My honourable friend, who's got more experience of this than anybody, reinforces my point, really. I mean, frankly, if I had a magic wand in this, I would force the Post Office to re-audit every set of accounts right back through 20 years and then give back the money. But that's not going to happen. And anyway, it would take forever, and this thing would drag on forever. And we know the stress that this is causing on postmasters even today. But the point I'm worried about here is that we may feel at the end of this we have solved the problem. And yet there will be a few, and I'm only talking maybe dozens or hundreds, not thousands, there will be some who will be left not absolved, not exonerated, who deserve to be exonerated. And that's the risk of the approach we're taking. So I think we have to look at this, and it may not be resolvable through... I will give way, yeah.
I'm grateful to my right honourable friend for giving way on that point. Given his line of argument, does he have reflections on whether we should be including within the scope of this bill those who did go to the Court of Appeal initially but lost, or those who were not given leave to appeal, on the basis that we simply didn't know then what we know now? A handful of cases, maybe under 40, but should we be providing for them in this bill rather than excluding them?
Those are precisely the cases I'm focusing on. Those are the most obvious ones. There may be others we don't know about, but those are the most obvious ones. And I do think that. But if I had my way, again, if I had a magic wand in this, I would use my mechanism I talked about before, unretire a few Supreme Court justices and say, these are more complicated. These require a bit more insight. These you can't deal with en bloc. Will you please reconsider them? You know? Because on the one hand, I want to exonerate people who are truly innocent, but on the other hand, I still get postmasters calling me up and saying, whatever you do, don't exonerate the guilty. So it seems to me the best way to do this is a judicial or quasi-judicial route over and above what we're doing here. But no doubt we will debate this at some length in report stage. Now, so that's one point I'll make, but I'm still going to support this bill because at the end of the day, it's the difficult compromise the government has found. Talking to everybody, including the right honourable member for North Durham, who's not here for the minute, and taking all the expert advice, and they got to where they are. And it's necessary, because I had a telephone call just the other day, in fact, yes, actually it's just yesterday, to a victim of the scandal. I mentioned it in my earlier intervention. Who's well, I may as well name her. Her name is Janet Skinner. She's not my constituent, but she called me anyway. And she just told me in terms that she's still going through, 15 years later, she's still going through misery. The post office is still, despite having promised me they wouldn't do it, the post office is still putting her through the sort of inquisition, really, demanding documents from her from 15 years ago, during which time she's been in prison, right? And had to sell her house, so probably got no documents anyway. You can just think of the disruption of that. Documents that they themselves will have somewhere, or if they don't have, they ought to have. And that's still going on. This barbaric mindset on the part of the post office, frankly, a sickeningly inadequate and self-absorbed post office management. We've seen them giving evidence in front of the Right Honourable Gentleman's committee. So this problem is there, and we have to get this underway as fast as possible. So the minister and I, by the way, I pay enormous credit to both of the junior ministers who dealt with this. I think both of them were formidably good at their job at a time when, frankly, the whole system was, the whole Whitehall system, the whole post office system was desperately trying to ignore it. They really did a heroic job of dragging this back up the priority list. So, he needs to be able to release, as it were, to get back to solve that problem and to force the post office, or to force somebody else in place of the post office. The Right Honourable Member for North Durham's point, really, to force somebody else in place of the post office to put this right quickly, easily, gracefully, and to minimum stress of the postmasters. Thank you.
Thank you very much. Marion Fellows.
Thank you, Mr Deputy Speaker, and I have been listening intently to everything that's been said today. I think I'd like to reflect on the number of times I've stood here and talked about the Horizon business, and I don't want to repeat my remarks, but I agree with the Honourable Gentleman, the member for Stalybridge and Hyde, and everything that he said, and what has always been repeated in this chamber many, many times. And we're coming close to a point now where we may indeed see a movement towards justice for sub-postmasters. And an exoneration bill is vital in that way forward. And I am deeply, deeply disappointed that Scotland has been left off this bill. I have been working hard with the Honourable Member for... I've forgotten his constituency, but I've had many meetings with Northern Ireland MPs on this, many of them from all parties. And I think if Northern Ireland is to be included in this bill, I can see absolutely no reason why Scotland can't be too.
And particularly the Northern Irish members on this matter. But certainly, Northern Ireland is a very special case of its own anyway, for reasons we all know. Is there a reason why the Scottish Parliament, the Scottish Government, couldn't simply replicate this bill and carry it through?
Right Honourable Gentleman for his intervention. There is absolutely no reason, and they are indeed prepared to do that, and there is ongoing work in this case, but it will mean that Scottish victims will have to wait longer for exoneration. Okay.
The Scottish Parliament has provisions in its own standing orders for emergency procedures, just as we have. It would be open to them to do it in 3 days if they chose to.
Yes. I thank the Right Honourable Gentleman for his intervention. I am being surrounded by lawyerly people, and I am not a lawyer. In fact, I sat in a room with... I bet...
Well, not guilty of that anyway.
Not proven. I sat in a room last night at a briefing where I was surrounded by lawyers, and even the lawyers were agreeing they couldn't agree on the right way forward. So, and as for what the Right Honourable Gentleman from Orkney and Shetland said, he's absolutely correct, and the Scottish Government will do that. But they can't do it until they see actually what happens in this bill, and to see this bill into enactment and to take into consideration all of the amendments that might be necessary for Northern Ireland as well. So that will delay. And yes, they will and can. And I can't say they will because I'm not a member of the Scottish Parliament nor the Scottish Government. But it is possible for the Scottish Parliament to pass a bill, an act, in the 3 days and have it aligned. But it must be aligned with the exoneration bill here, because otherwise Scottish victims are not being treated equitably and fairly. And my issue today is, on the 10th of January, the Minister spoke in this place and spoke to the Honourable Member for Edinburgh West, I believe, and said he saw no reason at that point as to why there could not be UK legislation. At an interministerial standing committee on the 12th of March, and the Secretary of State, now I'm sorry, I have to read this title in full, the Honourable Secretary of State for Levelling Up Housing and Communities actually said that he saw no reason why this couldn't happen, and yet a few days after that the bill arrived in Scotland with no mention of Scotland at all. And it's the Scottish Government's belief that the bill could be amended to take into consideration the differences in legal terms. For example, there'd have to be a line on embezzlement, and there would have to be different measures, different amendments made to make it apply in Scotland, and covering all the different crimes, if you like. Well, not crimes, because the sub-postmasters did nothing wrong, but it could actually clear the decks for all the things they were charged with and convicted for. So it's all very possible, and it's the timing issue, and it's okay, you'll wait, and yes, but you'll have to wait longer. And in this house, and in this place, and right across the work I've done over the past few years on post offices, there has always been agreement, cross-party agreement, to get things sorted out for the victims. And I think, as the Honourable Gentleman for Stalybridge and Hyde said, this is the point of this whole thing. It's about the victims. Yeah. And it's about what's happened since Mr Bates versus the Post Office was released. And I sat with my daughter-in-law, herself a lawyer. I don't hold that against her. And she kept saying to me, "Is this true, Marion? Is this true?" And I had to say, yes, it was. The Minister wants to intervene, yes.
Thank you once again for all the work she does. And as I said to her on a number of occasions, our officials are working on a weekly basis, and I've met with my counterparts in Scotland about this particular issue. I do think, clearly, she will acknowledge this Parliament is taking a political risk doing what it's doing. This is unprecedented and unpopular in some quarters. Does she not accept, as politicians, at times we have to stand up ourselves and take that responsibility and accountability, just in the way the Right Honourable Member for Shetland and Orkney said, that we accept political responsibility for doing the right thing in our own jurisdictions?
I agree with the Minister. Of course I agree with the Minister. But actually, let's think about back to the victims. Scottish victims shouldn't have to wait any longer than victims across the rest of the United Kingdom. And if the Scottish Government were to expedite a bill in the Scottish Parliament without knowing exactly where this bill is going to end up, because already today there has been talk of amendments to it to help Northern Ireland, then that wouldn't be right either. But I do want to move on. Very well.
Extremely grateful to her. I'm absolutely willing to listen to the case that she's making, that you could amend this bill in theory to cover Scotland. I don't, if I'm being honest, follow the logic that it would take longer to pass a bill in the Scottish Parliament affecting Scottish sub-postmasters than to amend this. And to be honest, I don't agree with the point that extending to Northern Ireland would any adversely way affect the Scottish situation.
And the Honourable Member has every right to disagree with me, but I come back to my main point, that the Scottish legislation would have to be a mirror of what is done here, so that we're treating victims across the piece the same way, but there have to be certain amendments made because of Scots law. And that's my point, because we can't do it in Scotland until it's done here, so that it actually mirrors and is reflective of what has been done here. I don't want, Mr Deputy Speaker, I think the other point I want to take is this is not anything to do with the Scottish Parliament or the Northern Ireland Assembly. The whole business of Horizon arose here under the Post Office Limited, which is wholly owned by the government, UK government, being the single shareholder. So there is a logic to saying the mess is made here, it should be cleared up here. Now, people and cross-party, everyone agrees this has to be sorted, and that this bill, no matter whether it ends up being a separate bill in Scotland or this bill that's only England and Wales, is not the thing that we would all want to do, because it's unprecedented, there are risks, all of that. But at the end of the day, it has to be done. And Scottish Government understand that and are supportive of the fact that it has to be done, but just still want it done here first, and then it covers everyone. It's really, really important that we get...
Most grateful to the Honourable Lady, and she has been very generous in giving way. In terms of the Scottish Government wanting to see what happens here, we've heard that it can be done in 3 days. The Honourable Lady is saying they want to see what happens here. Once legislation goes through here, in a matter of days, not weeks, in a matter of days, it can be replicated in Scotland, and it can be passed in 72 hours. So, given that this matter has been going on for years and years and years, the concept that it can get through in Scotland in a few days more, I fail to understand what the big issue is as far as the Honourable Lady's argument is concerned.
There is absolutely no guarantee that it would just be a few days more. But at different timings of Scottish Parliament sittings, there's lots of considerations that the Honourable Member won't know about and doesn't normally need to know about. So I will move on. I think it's becoming clear, and I have had that I will be seeking to amend this bill. I will be taking advice, and I will attempt to do what will be done in Northern Ireland. I'm well aware that this may seem a futile exercise to some, but this is democracy, and this is what has to be done from a Scottish perspective, and I am more than happy to take that on board. I'd like actually to close with some messages that have already come out across the chamber. As a constituency MP, I first had a meeting of sub-postmasters in 2015, a few months after I was elected. Had no notion of what Horizon was or the damage it was doing to my sub-postmasters. And over the last almost 9 years, I've had to listen, and more recently since Mr Bates versus the Post Office, I've had to listen to grown men trying not to cry because of what Post Office had done to them. None of them, not one of them, and also the women I've spoken to, not one of them was actually charged or was actually prosecuted. They just kept putting their own hard-earned cash into their tills so that they could open their post offices at the next morning. And although I have pleaded with them all and plead again across the UK for people who have been affected to come forward, the lack of trust, and some of these people, the ones who were prosecuted are suffering. The ones who weren't are also suffering from PTSD because they're so traumatised about what has happened to them. And I want to also raise a case very quickly of those who work for partners of the Post Office, people who work for ASDA or ScotMid or CJ Lang, who were sacked by their employers and couldn't get an equivalent job, who were depressed and ill for years as a result of this. And going forward, we really have to take into consideration these people. I understand that a bill cannot be a magic wand and make everything go away. I do understand that, but I think it actually is imperative for this House to keep at it, and I would agree with my right honourable friend, and I call him that gladly, from North Durham, that we can't put a time limit on things, because what then might happen is that people don't get the justice and the redress they say. I'd be very happy to speak to the Minister later and catch up with all the toings and froings between Scotland and this place. But I still stand here saying this is what the Scottish Government have looked at, and they won't, because they think it's best for the victims in Scotland.
Mr. Scully.
Thank you, Mr. Deputy Speaker. And can I thank everybody? It's been a real privilege to sit here listening to the amazing contributions from the Secretary of State, the Shadow Secretary of State, and can I thank him for his kind words. But all of the others that we've heard today and will hear after my short contribution, because we have been coming here, as we've just heard from the Honourable Lady Member for Motherwell and Wishaw, that for years now, for years and years, coming back time and time again, often repeating ourselves, but we have to repeat ourselves. And this is the point. And the Shadow Secretary of State talked about the amazing drama, that powerful drama, Mr. Bates versus the Post Office, and what that did with the public outcry in this. When I became Minister of February 2020, it was shortly after the GLO case that was featured towards the end of that. I'm pretty sure that Alan Bates, the email that he was typing out to the Postal Affairs Minister was me, that he was posting out, sending in quite a large invoice, which I politely declined to pay at the time. So I suppose I had pages and pages and pages of judgment by Justice Fraser to look at, to reflect on. So I was in a different position from my predecessors, other Postal Affairs Minister, who maybe should or should not have actually sat there and read the runes and see what was going on, why there were so many people, why prosecutions were going up and up and up over 20 years. But what I did have was that pages of damning judgment from Lord Justice Fraser. And what we've seen now with the Alan Bates documentary, the ITV documentary, it is that public outcry that's really risen. And I think it's given the Postal Affairs Minister, my honourable friend, the member for Thursk and Malton, the power. He has been working tirelessly in his time as Postal Affairs Minister. He read out the timetable of work that he's been doing since I left that role. And it's been incredible, because I know he's a man that understands justice, understands what justice looks like, and fairness. In his previous work, looking at financial scandals, the HBOS situation in Reading, and it was always a constant coming to me in that role with those kind of miscarriages of justice as well. So if anybody was going to be carrying on, really delving into this work, it was always going to be my honourable friend. So I think that documentary really helped him pull some of the levers that were sometimes, as junior ministers, we need to do to be heard, to make sure that in other departments we can swim through the treacle sometimes to make sure that we can get things done. So more power to his elbow. Now, we come therefore to why we're doing this in the first place. This is often seen as a software failure. Even in the documentary, it was a deliberate, dramatic plot device to have that computer sitting in the corner of the post office there, sort of blinking away at some sort of slightly alien life force that was draining that money away. It wasn't a software failure, it was a human failure. We all know that software goes wrong. We just come out of the Millennium Bug situation, if you remember. We know software goes wrong. Where the problem was is that the way that we had groupthink, that we had people doubling down for reputational management, for all of those kind of things, that were pushing back, making sure these postmasters believed that they felt they were the only ones having this problem. But we know now, and we quickly knew, that there were hundreds and hundreds and hundreds of people in this situation. And I tell you what, when we're talking about the fact that it is a human failure, means that we need a human solution. We have to be humans first, politicians second. And it's the Honourable Lady talked about watching grown men try and stop him crying. I tell you what, I'm not the best at doing that myself when I'm actually and I'm not directly affected by it. But just recently, I was at the GG2 Awards, Asian Awards around the corner from here, and totally a surprise to me, I saw Hasmukh Singadia, Vijay Parekh, Vipin Patel and Seema Misra. Many of you know Seema and her story in particular. She was pregnant at the time when she was being charged from West Byfleet. They were getting awards, they were getting recognition there, and it was so lovely to see the outpouring of support for those people in the room. So if we look at what we're trying to do now, yes, I'll happily give them.
Very briefly, would my honourable friend agree with me? These are the ones who receive the awards, but actually an award is due for every single sub-postmaster.
For sure, for sure. Look, there is my honourable friend raises a really good point, because look, we cannot do enough for these people. They have literally been cast out as a pariah in their communities. They have been put in prison, they've been charged, they've put in prison, they've lost houses, families, health, all of that, from something that ultimately is owned by the state. We, as a collective body, have destroyed these people's lives. So there is nothing more. There's not enough that we can do for these people. And the other thing I would say as well, when we are looking at this legislation and all the other compensation schemes as well, we do have to act. These are people that we tried. The reason that we're having to do this mass exoneration in the first place is because the wheels of justice work slowly, yes, but also these people are so triggered, whether it's PTSD, whether it's just total mistrust of the system, they do not want to go through another process with someone else from authority saying kind words, warm words, and then letting them down a second time or worse. So it's actions that we will be judged on, not words. When I stood up at that dispatch box, you know, for everything I could talk about, people, I knew, I didn't expect people, the postmasters, to trust me. They trust me on their actions, and I know my honourable friend feels the same way. So we come to the legislation that we have at the moment, and I really, really welcome this, and it's important that we don't let, what's the phrase, let perfection be the enemy of the good. Let's get this done, because we can't get onto the second bit. We can't get onto their compensation until we've had them exonerated. And that's not pardoned, it's exonerated. They've done nothing wrong. They've done nothing wrong. So let's make sure we accentuate that as well. So we can't even get to that second stage. So that's why I'm really keen to rush this through. Yes, we need to scrutinise it. I'm not saying that we do not scrutinise it, but it is a short bill. We can do this quickly, and then we can get on to that life-changing money that I always keep talking about, we always keep talking about, for reasons that trying to restore some sort of semblance to these people's lives who, as I said, have been destroyed. So, you know, this is a second reading. We'll have a committee stage and a report stage when we'll get into some of the specifics that have been discussed earlier on. But let me possibly just offer a few solutions. And I think the kind of solution that my right honourable friend was talking about earlier, when bringing back judges, at least adding capacity to the system, that it was something that I think my right honourable friend, the member for Bromley, is no longer in his place, had been saying at previous occasions, when he was saying, actually, we don't necessarily need this kind of law, which is, frankly, trampling quite a lot on the independence of the judiciary. Hence, the government had to go really carefully in this, which is one of the reasons that some of the concern that was raised by the Select Committee about the people who have not been able to go to appeal or won't be included in this because they were being refused to leave an appeal or they failed their appeal. There is still more we can do for them. They will be able to appeal another time, but maybe there is something we can do in the way that my right honourable friend and my right honourable friend for Bromley as well have said in their previous contributions to accelerate their cases. So not just let them have to go through the same situation as they would otherwise have done. And perhaps, may I respectfully suggest that may be a case for Scotland and indeed Northern Ireland. I'm no expert, so I'm not a lawyer either, and it's not for me to give advice, but it's just something that occurs to me as I'm listening to the debate, that if that amendment does not go through, if the territorial extent stays as it is, and that's for this place to judge in other stages of this bill, then perhaps there are other methods that we can use to make sure that postmasters in Scotland, postmasters in Northern Ireland are not at a slower stage of events, because we all want this to be done. We all want this to be done as quickly as possible. My honourable friend, the Post Affairs Minister, has talked about getting the majority of the compensation done by August. Clearly that's not going to happen with this category because we'll only just got this bill through, so we'll be having to exonerate them. But if we can do the HSS and the rest of the GLO done, but largely by that kind of time, then you know what? If we can restore these people's lives to some sense of normality, then we can do the rest of it. We still haven't finished because we've got to get Sir Wynn's report back. We've got to get that investigation done. And I remember, if you're looking at the time, I remember even we were some previous contributions talking about how this might be weeks and months and complications. I remember speaking to the solicitors that were representing the 555 and the GLO then and said, look, even if we gave you a wodge of money, if we gave you lots and lots of money and you distribute it, how long would it take? About 18 months. So even their solicitors themselves, because it's just how do you apportion it, how do you work it through, the same kind of things that we've been wrestling about with the advisory committee, they would have to do internally anyway. So it's not a matter of just here's life-changing money, one block, and give it, and then everybody's okay. It's making sure that you can work through that system, which will inevitably take time. Even Wyn Williams' investigation, when I made it non-statutory, it was to try and get speed. It was trying to get speed into the system, so make sure that we didn't have to lawyer up, as I described it. I want money to go. I always wanted money to go to the victims, not to lawyers just talking about the same things again. But what we now need, as I say, if we can get that compensation done, we've got to get the answers. We have to get the answers. We keep on talking in this place about this, about the blood infection scandal, about any number of scandals, saying, and the number of times I keep hearing people saying, it must never happen again. You know what? It usually does. And why? Because we talk about it, we talk about it, we talk about it. We don't learn the true lessons. We don't get those answers. Yes, sir.
Well, exactly that is one of the things we have to stress in our debate, both now and later, is how we stop this happening again. And I reiterate the point I made in my speech, which was when the Dedeker inquiry looked at it, it was systemic failure right across the board. He's right to say it's a human failure, it was a system failure, it was an organisational failure. And one thing I would say too is that the Post Office is an arm's length department. What we're finding in this and other cases is arm's length departments are disasters when it comes to correcting mistakes and delivering accountability. And does he think we might think about that when we're doing this?
And as usual, comes up absolutely on point, because this in our department as was, there are a number of arm's length organisations and departments that we have. Of course, thank you. Deputy Speaker, forgive me. And that's true in other government departments as well, because what inevitably happens, they are representing. They're representatives of government, and inevitably it will be us as elected politicians, us as government, that are held accountable for this. But if there's no direct relationship, it's very difficult from that dispatch box to really speak with enough authority, enough information to be able to take that accountability. So let me just finish.
I'm grateful, and I commend my honourable friend for a very passionate and committed speech. The point that is being discussed in terms of learning lessons is very, very crucial. And I fear, as do others in this chamber, that in old times you would say that the file will sit on a shelf collecting dust. Nowadays it would be archived and it would just stay there. Does my honourable friend agree with me that there does need to be serious attention paid to ensuring that there is a learning process from this episode, but as well as the countless other occasions when things go wrong, and that there needs to be some sort of setup to make sure other bodies, voluntary organisations, or those at arm's length, actually do take on board what's been said?
Absolutely. Really, really good case in point. And he will, I hope, be in the next Parliament to help drive this through. I've said I'm stepping down, so I'm not even going to see, from these benches anyway, Sir Wynn's final report. So I hope this House really does take that to heart and drive that kind of lessons learnt through. I'd commend actually a book, Matthew Said, who wrote a book called Black Box Thinking, when he compared accidents in the NHS to accidents and near accidents in the airline industry. and how the thinking in anything on an aircraft, even if it's just a near miss or something like that, gets learnt. Not only just learnt for that airline, it has to be passed on to every airline in the world. So that is a total industry collective sense of learning. Yes.
Yeah, I'm grateful to the Honourable Gentleman for giving way, and I've enjoyed his considered speech so far. Does he have a potential solution, or when he was a minister, regarding what my honourable friend for Motherwell and Wishaw mentioned, which is the employees in Asda Scotland who have been caught up in this scandal?
I didn't. I thank him for the honourable gentleman for that question. I didn't, but it is worth looking at, because it is, as I say, a human scandal, and it's not just those people, the directly affected people, the postmasters. I'm not sure how you start to unpick that, the wider and wider it goes, but it is an important one to reflect on, and I hope and I trust that the government will reflect on that in that wider learning and that wider viewpoint. But yes,
I'm tempted to intervene on two interventions that I heard recently, actually, so that's impossible within here. But on that particular point, it is certainly possible that the person who had the contractual relationship, in other words, the business concerned, Asda or a small post office, could submit a claim to Horizon Shortfall Scheme, which could include amounts that were paid, that should be paid to individuals who work for them, and compensate them through that route. Now, the other point on governance, as well as the fact of looking at public sector or quasi-public sector organisations here, I think it would be dangerous just to assume that's the problem in terms of governance. As he said before, I've dealt with, from the backbenches, a number of scandals that involve private sector organisations, Lloyds and RBS, where we saw years of obfuscation around the similar kinds of problems. So I think we shouldn't jump to the conclusions. We should probably let the inquiry report first and have a debate from there.
Honourable friend makes a really good point. I suppose what I was saying to follow on for from the intervention was, for my right honourable friend, is that it is difficult for us as parliamentarians. It's doubly difficult for government ministers to be able to stand with authority speaking on behalf of another organisation rather than a private sector which you're not speaking on behalf of, without necessarily having all of the facts, because there's only so much you can drill into. But I'll just conclude very quickly with the fact that obviously we want to right the wrongs of the past. Obviously we want to make sure that these people are restored as best we can, so that they can have a future for themselves and their families. But also there is the case in point of the post office itself. The post office still has more branches than banks and building societies put together. They still offer a massive I know there are certain areas there, this is a whole other debate, I'm sure, in Westminster Hall or something about closures or otherwise of post office. But nonetheless, the post office has a massive impact on people's lives, especially in rural communities. And so we mustn't forget that when we are looking at the post office, looking at the brand, the overall aim of the post office. This is not a reflection on talking about the current management or anything like that. But we have to give the post office a future, because lots and lots of... Yes, I'll happily give it.
Thank you, Mr Deputy Speaker. And I would also like to thank him for his work both in this issue and on other issues, protecting local post offices and looking at the range of services they can offer to the community. I just wondered if he had any further reflections on this very important matter about the role of post offices in communities. And I would also like to thank him very specifically for some work he did to support my constituency. Perhaps he could tell the House his own thoughts, now that he's left government, on the role of post offices as part of our local community and the potential for new services to be based from them.
I thank the honourable gentleman, and I appreciate his kind words when we work together on his constituency issue. But I'll just confine it to the fact that we ask the post office to do a lot of work on social value and economic value, and often that conflicts. It's a really difficult thing to get absolutely right, because we cannot ask the post office to turn a good profit as if they were just an ordinary another bank or something like that, and do the things that we sometimes ask and expect as parliamentarians, in particular when we're talking about our own constituencies, especially people that represent more rural areas. So that's just the future. That is something that we've got to give careful consideration for. But the wider point, the original point I was trying to make, is that whilst we are righting the wrongs of the past, we've got to remember that this is an important organisation for our country and our constituents. We've got to give it a future as well. Thank you.
Thank you, Mr. Deputy Speaker. Can I first begin by declaring an interest as a member of the Horizon Compensation Advisory Board? And can I say what a pleasure it is to follow the Honourable Member for Sutton and Cheam? He was a person, when he was a minister, who grasped this issue, drove it forward, and I'm sad to see that he's standing down at the next election. But one thing he can, I think, claim great credit for, he was the only minister that I've dealt with, apart from his successor, who actually not only had compassion and understanding and wanted to sort it out. Now, okay, I agree we had disagreements on occasion, some quite heated, but at least he was prepared to listen. And I think that was a unique set of skills he brought to this. So I think when he leaves the House, he can have this as a great mark on his parliamentary record of actually doing a great achievement for those individuals. I welcome this bill today. It was a solution put forward by the Horizon Compensation Advisory Board, and can I pay tribute to Professor Chris Hodges, Lord of Bethnal, and Professor Richard Moorhead, who sit on the advisory board with us. When we came up with it, did we think that the actual government would actually agree to it? I've got to say, no, we didn't. And were we shocked when it was actually agreed to? I think we still were. I'll not say what Chris Hodges said at one meeting privately, because it would be unparliamentary. But I think what it showed was that this was a very difficult thing to do. And it comes, as people have already said, after years of campaigning and a heartache by those sub-postmasters. Alan Bates has already been mentioned, and can I again pay tribute to him and the 555, because I think, as the Honourable Member for Sutton and Cheam mentioned earlier on, without them and taking that court case, this wouldn't have actually, the dam wouldn't have broken. And it is down to those individuals to have the tenacity. And over the years, has it been easy for those individuals? No, it is not. And, you know, as someone's been involved in this for many years, I'll tell you, you do self-doubt yourself sometimes, thinking, are we missing something here? No, we weren't missing something here. It was actually a complete injustice. But when you've got the system, which they had the system, and the state against you, it takes great courage and great tenacity to continue on what they do. And I know along the way some, you know, had self-doubt, but, you know, credit to them, they stuck with it.
One of my Robert Friedman would give way on that point, because it's just not in this case, in the Horizon case. It's also Hillsborough, Grenfell, Windrush, the contaminated blood, where we're still waiting for compensation to be paid, where the state and the justice system, which are there to protect citizens, actually becomes the enemy of the citizen. And does he agree with me that we need to find a way for these people to get quicker redress and get their cases heard, and not have the state say we can't be wrong in any circumstances, and leave these people to have to fight for such a long period of time to get justice?
I agree totally with my honourable friend, who again, can I pay tribute to him, because in all these debates over the years, he's always been on my right-hand side here in terms of arguing for his constituents. So thanks to him for his work and persistence on this. But he raised a bigger point here, and it is, when the state gets things wrong, and so badly wrong that they did in this case, but he mentions other occasions as well. It goes into tortoise mode, where, you know, it comes around itself, and, you know, they can't be wrong. Well, they have been wrong. And we do, and I don't make a part of political point here, because this is not one. I do think across the House we need to come up with a system of dealing with these cases, both in the transparency that we need in terms of information to get out of the system, but also, as he quite rightly says, having a swift compensation system for putting those things right. And I think, you know, that is something for the next Parliament which we need to work on a cross-party basis, because, as the Minister said earlier on, I mean, he was involved in a number of cases which weren't the state, it was the private sector, but had very similar things. And it's something I would certainly like to work with colleagues on. Can I also thank the Minister for his work on this? The Minister, I would describe, is not a show pony in politics. He's one, I would say, is the steady shire horse of this place, who is solid, determined, and pushes on, even when obstacles are put in his way. And also credit to him for the work that he's done across party on this. He's not seen this as point scoring. He's worked very closely with my honourable friend for Stalybridge and Hyde, and I know other members across that, and I really appreciate that. And I would just point to possibly new ministers after the next general election. If you want 2 examples here of how to do the job, the member for Sutton, Cheam and the minister, they are it. And I think they should take credit for it. Now, today's bill, as been said already, is an historic bill. It is. We're doing something very unusual, and it is a very delicate balancing act to be struck between this place and the judiciary. And can I say, Mr Deputy Speaker, I understand that. I always respect the judiciary. But I also reflect on the fact that the judiciary have also got some questions to answer in this process. Now, we had the trade union movement for the lawyers early on when we had the Right Honourable Member for Bromley and Chislehurst and Right Honourable Member for Swindon South on their feet. Well, it wouldn't be debate without that lobby coming in on it. But, the judiciary need to ask the questions and reflect, how did we get into this position? In terms of, because, there was a pattern here, there wasn't questions asked in terms of robust questions. I've got to say, when I think the Ombudsman from Bromley and Chisler said we shouldn't attack certain judges, well, I've got to say, if you actually see the conduct of certain judges in some of these cases, I'm not sure they were very sympathetic to the victims in it. And I think you just need to reflect more on that. I'm not one that thinks that this place should interfere in the judiciary, but I just think that this instant reaction that somehow this is a fight between Parliament and the judiciary, no, it's not. But this case, they got it wrong. The other area which desperately needs looking at as well is the issue around computer evidence in court cases. Because at the moment, I think, as was mentioned earlier on, it's like looking at a machine. There's no reference to computer coding and other things in there. And I think an urgent review after the election or soon needs to be done to reflect the ever-changing nature of the way in which computers are not static machines, but are actually, might be physical machines, but actually the software coding and things that change it. And that is not reflected at the moment in law. And that, I think, is important. But I do support the approach which we've got. And I accept that there are people that aren't comfortable with this approach. But as the Minister said earlier on, there's only 103 cases being dealt with so far. And can I just explain why I'm committed to this and came to the conclusion this is the only way to deal with it? And I give it by example. Last year I had a phone call from an individual, and I'll say in the northeast because I don't really want to identify the individual in any way. And he said that his friend, wife, had been prosecuted, and he thought it was an Horizon, to do with the Horizon case. So I said, yeah, get him to speak to me. I'll speak to the husband. I'll come and see them. It took me a while to get to speak to the husband of the victim. And that individual finally agreed to see me. It took me quite a few months just because he was clearly trying to persuade her to meet me even. And it was only when I went to see her that you understand why these people never come forward. This is a woman who had run a post office, had a successful business, was prosecuted by the post office. When I sat in a small council flat in the northeast of England, someone who should have had a comfortable retirement and actually had a highly respected name in the local community she still lives in, didn't. This was a woman traumatised by this experience. She was very reluctant to see me. She was terrified, and I use the word terrified, and she kept saying, my name's not going to get in the papers again, is it? And I said, no one's going to know about this case. You know what you're telling me. And that, I think, demonstrated to me that the idea that she would ever have come forward to go into a court process is not. Now, I've subsequently spoken to the family and reassured them that if this goes through, she's not going to go to court because she's terrified. That woman's good name is going to be cleared, and she will have access to compensation which rightly deserves. So that is just one example. There are numerous like that. So when people are saying, is this a messy way of doing it? No, I don't think it is for people like that, because they would never have got justice any other way without that. And, you know, people might be uncertain about what we're doing, but I'm not. I think this is unique circumstance. I don't think it sets precedents, but I think we can actually ensure that those individuals have their good name restored, because if you live in a small community where you've had newspapers when you've been convicted that you stole money you didn't steal, now that takes a lot of doing, even staying in that small community. And that was 20 years ago, and she's still traumatised by it. So that is the reason why this way forward is the right approach. Now, can I also take the opportunity to welcome the announcement last week of the fixed awards which will be offered to the HSS scheme. This is something the advisory board has been pressing, and I think fair to the Minister, he has been championing as well. And this, I think, is a good way of ensuring that we can try and get some cases dealt with speedily. Now, I read the Select Committee report. I disagreed, I've got to say, with the time limit issue, because what we need to do is get those, say, straightforward cases. They're not all straightforward, but some are. We need to get them settled. And the Minister, like me, does not want to pay lawyers. And if we can actually not pay lawyers and actually ensure that that compensation goes to the victims, the better. And this is definitely the way to do it. And I think where the Select Committee perhaps misunderstood what they think, I consider this like a bucket. You've got all these people that are in it. You need to take out the simpler cases, and then the more complex cases you need then to look at and will take time to do. And that's not just because this is easy to fire at the officials, saying the officials are slow or somehow are deliberately slowing down the system. I don't accept that at all. But these are complex cases. And they're also complex cases. Even if you speak to the lawyers who are representing some of these people, you need time to do it. And as the Minister knows, we've got some that are going to be very expensive as well, more than the £600,000, quite rightly, in my opinion. So I think that approach is certainly the right approach to do.
My right honourable friend, away from that point.
Thank you, Mr Deputy Speaker. My right honourable friend is making an excellent and very powerful speech. I particularly concur with the way that he's described the enormous challenges that many victims face. Does he agree with me that the point he's just made about the nature of any review or development of policy is particularly important? Because if we can find a way to try to speed up compensation in a fair way, which deals with some of the slightly less difficult cases first, it could benefit everyone, and it may also reduce the cost to the government and to the public.
Well, I think it is, and I think fair to the approach of the Minister, he wants to get these cases done quickly. I want to get the advisory board want to get these cases done quickly. Now, one of the controversial things is some of these people will possibly get a little bit more money than they actually lost. Now, personally, I sit comfortable with that. I'd sooner they get the money than actually go to the lawyers or actually have the process dragged out over a period of time. So I think if we can get those cases dealt with speedily, and there's some progress I think on that, let's then get the effort and force put into sorting out the more complex cases. Yeah.
He quite rightly says that some may get a little more money than is perhaps comes out of the arithmetic. But isn't it true that, frankly, most of us would pay anything to avoid what they've gone through?
Exactly. So therefore, frankly, if somebody gets more money out of this than they actually perhaps, in quantum lost, I'm comfortable with that. I think fair to the Minister is comfortable with that. And if it's better in their pockets, in my opinion, than put it into the pockets of lawyers who will and take the time. And added to the trauma that these people are going to have for dealing with these over many years. Can I now turn to the in the bill, the Horizon pilot schemes and the details that it introduces. because we have the pilot, we have the Horizon scheme, but then we have the pilot that came before it. Condition E overturns the convictions in the bill is that the Horizon system is in the first offence. So clause 8 of the bill defines that any variation of computer system known as Horizon and sometimes referred to as Legacy Horizon, Horizon Online or HNGX, used by the Post Office. We know, because having been able to recite some of these things in my sleep, that there is a difference between those pilot schemes and the actual Horizon scheme that it took over. Now, people used the Horizon pilot scheme in the North East as early as 1996, who then went on in some cases, one to be convicted, but others actually lost their livelihoods and were made bankrupt. So I recognise that 1996 is the start date on the face of the bill. But if you look at the Post Office website, which I checked again this morning, it says the rollout and pilot of Legacy Horizon refers on the face of the bill to Part E. It starts at 1999. So what systems were people piloting in 1996? And was it Legacy Horizon? Because that would be at odds with what's on the Post Office claims website. So I'd just like the Minister just to refer to that in his wind-up, because I think that would clarify something, especially because a lot of those cases were in the northeast of England, in the area which I represent. Now, can I now turn to another system, which is pre-Horizon, which was the capture system. Now, this was developed, and it was a software, as I understand, developed by the Post Office themselves. Now, I came across this by cases that have been referred to me. It amazed me that the Post Office and all the publicity around the Horizon didn't actually come clean and say, oh, by the way, we actually had Horizon, pre-Horizon, then the capture system beforehand. Because in these cases, if you look at them, it's very much it's because of the attitude of the Post Office in terms of prosecutions. We had sub-postmasters who were accused of stealing money and their contracts terminated. In some cases, they were actually prosecuted in these cases. And also a ridiculous situation, one I've got in Coventry, where a woman was prosecuted, taken to court. The judge threw it out on the first day of the court case, saying there was no case to answer. And then, lo and behold, what did the Post Office do? They then took a private prosecution against her to recover the £30,000 they claimed she'd stolen, i.e. bankrupting her. So that just shows the mentality that there is in the Post Office. Now, a lot, as I say, mirror this system. I've currently, I think, 10 cases, which I know the Minister, I've referred to the Minister, and 5 of these individuals actually went to prison as part of this. And I'd like to put on record again, which was done before, Carl Flinders from Computer Weekly, who's been working on this, and Steve Robson from the iNewspaper, who's done some excellent reporting on these individual cases. But it's been, I've got to say, down to me and those 2 individual others doing the detective work. And we do need the Post Office really to turn, to actually turn the heat up and actually try and make sure we get the answers to this. And can I just say to the Minister, could he tell the Post Office it's not a good idea to threaten to sue journalists or take legal action against journalists? This week, Steve tells me his latest story, apparently he got a threatening phone call to have legal action taken against him. Not very, very bright, basically because he had all the evidence to stack up his story. But if that's the attitude still in the Post Office, I'm sorry, that just again shows why I think the current management of the Post Office need to go. So it is important, and I understand why the government can't include capture in this piece of legislation, but we do need a mechanism for dealing with these cases, because I've got 10, there are more out there quite clearly. And I do understand the why the government don't want to do that. But I do note under Clause 7, it gives the Secretary of State the powers to make subsequent provisions by regulation. So would it be potential that we're a way of including the capture cases? He's got all the information, he knows he's on the top of the brief. I raise it today, and I will be putting an amendment down at report stage to see whether we're at committee stage to see whether we can just flesh this out a little bit more. But we do need some way of being able to deal with these cases. I've got 10. There are certainly more out there.
I'm glad you raised that point. I don't know whether he's in for my speech, but I made reference to the BAE study back in 2013, which highlights capture, highlights ATM cash management, and highlights a variety of other issues highly associated with audit failure, and basically describes a chaotic management system. And I do think we owe it to the earlier postmasters, who may have not been exonerated by subsequent analysis because people were looking for horizon, nothing else. We owe it to them to get that right as well, even if it's after this bill is through.
Because people think, oh well, this system wasn't horizon, therefore this doesn't apply to me. But there is injustice here, and you know, some of the cases I'm dealing with, and I've spoken to individuals who went to prison because of anything, and what it's about, it's not because the computer systems are the same, it's the attitude in which the post office went at individuals, that somehow they didn't believe the postmasters, that they were guilty, and they were going to be found guilty come what may of something.
I thank the Right Honourable Member for giving way. That approach about the investigation and the presumption of guilt, I think, was what the Honourable Member, my Honourable friend for South Ribble, was referring to with her constituents. That at the time it was Royal Mail, it's before the ownership transferred. So what she was talking about was exactly that. It was not prosecution, because it didn't get to that. It was the investigation officers, the same kind of people that we've seen at the inquiry.
Seen it first hand at the public inquiries from these individuals, and you know, people have said, well, you know, we're basically, everyone's come out of the woodwork who's going to come out. Well, they're not. They're still there. There are people still coming forward. I'm getting cases on a weekly basis, and you know, thank you to Honourable and Right Honourable members across the House who are keeping me busy referring cases to me. Please send them to me. I'm quite happy to help deal with them. I got another 3 I noticed in my inbox this morning. But the Honourable member makes a key point. We do need to look at these individuals, make sure we actually get some type of justice for them. Because if you just look, and I always got to say I was surprised, but if you look after the television programme, nearly 1,000 new cases have come forward on HSS, for example, alone. Now, then you say, well, what were these people doing all the time? Well, in some cases they weren't aware of it. In other cases, they were, as the Right Honourable gentleman says, they were hiding. They were hiding because of shame and things like that. And I think it's only because we've now encompassed the fact that this was the massive miscarriage of justice it is, that they've been able to the competence to come forward. And I think this bill will help with this. So we will have. Can I just touch on, while I'm on this subject, I'll come off capture, but I think the Minister's got my point on that. And that's the issue that was raised earlier on about those cases that have already been to appeal. Now, I do understand why the government aren't putting in, and I'm not a criticism of the government for putting, but we've got to find a system for dealing with those few cases that have been through. And it's no good, I think, the Court of Appeal hiding behind the fact they've been through, because there is new evidence that have come forward, as the Honourable Member for Sutton and Cheam has just said, that's come out of the inquiry, which was not available to the courts at that time. And I just think, you know, to leave those, I can't exactly remember off the top of my head how many individuals there are. There aren't that many hanging. Sorry.
Just to clarify that point, just in terms of the numbers of people that have come forward since the TV dramatisation, that's now 1,200. And in terms of the numbers that have been before the Court of Appeal, there's 7 that have actually taken their case and been heard by the Court of Appeal, 6 who have been refused leave to appeal, so 13 in total in that cohort.
Research assistant the Minister is. He's right. So we're talking, you know, nearly single-figure individuals. Let's look at those cases, Minister. Let's see if there's a way we can actually... and I understand, and I'm not criticising why they're not in this. I understand why they're not in this bill, but we need to look at them because there are those things that came out of the inquiry that would have changed things, I think, in some cases. Might not in them all, but at least we need to. Otherwise, they're going to be left there outside of the remit of this bill. Can I now turn to the territorial provisions in this bill? I think a case has been made earlier on in terms of Northern Ireland. I can see no reason why this bill shouldn't include Northern Ireland. And I think because we've got cross-party support in Northern Ireland for this, and I understand the executive as well are on board for this, I think at committee stage, you know, we need to recognise that. I've got to say to my honourable friend from the SNP, I have less sympathy, I've got to say, with the including Scotland in it. Not because that those individuals shouldn't get justice, they should, but I think it's a different issue in terms of two issues. There's one, the legal position in terms of the way prosecution is done in Scotland is slightly different, or very different to the UK. And also there is a mechanism there to do it. I think the Scottish Government just got to get on and do it. I accept what she's saying, they've got to perhaps wait and see what we do. But I think, you know, that would be, I think, a thing that I think would be, I think, get cross-party support in the Scottish Parliament if that was to go forward. But I do hope that there is some amendment brought forward on Northern Ireland at committee stage, and I'll certainly support that as well. Can I just finally talk about the notification of individuals? Because again, reference was made earlier on to the you know, record keeping, which was not brilliant at the post office, and we've got to try and find, I think the bill says, reasonable steps to notify individuals. I think we need to look at that because again, some of these cases will be legacy cases. Some people will have passed away, sadly, before they're able to get justice. So I think we perhaps just need to, you know, say what, how we actually get to those cases that, like I say, are possibly more difficult to get to than others. So in conclusion, Mr Deputy Speaker, this is a long overdue bill. It's an historic day to get to where we are today. And in conclusion, I think of this. I think of that woman who I sat in front of last year in a council flat in the northeast of England. That woman who has had her life ruined for the last 20 years has clearly had daily trauma because of the injustice she's gone through and the financial heartache which she and her family have faced. With this bill, will finally get justice. And that, if I do one thing in this House in my time here, doing that will make me, I think, very happy.
Yeah. Duncan Baker.
Thank you, Mr Deputy Speaker. It's a great honour to follow the honourable member for North Durham, and on that very poignant ending, which I think all of us will empathise with. I know he's done an enormous amount in this House to get us to today, and I thank him for that. And there is absolutely no doubt that today is a very good day. And it has been brought about by the Secretary of State, by the ministers, both past and present. They are not show ponies at all, as been suggested this afternoon. Indeed, the Prime Minister as well, for the actions that he took at the beginning of this year in particular, and certainly the chair of the APPG as well, who I've worked with many, many times, and I thank her for all her work. All of them must take credit for where we are. But we also know it has taken an awful long time, and the Honourable Member for Thurston Moulton is absolutely right when he said before that an awful lot of work has gone on behind the scenes to get to this moment. But I equally have total empathy with the comments that I receive from members of the public all the time that it shouldn't take an ITV drama to turbocharge us to where we are now. The people across the United Kingdom knew that this situation was utterly wrong. It begs the question to me, Mr. Deputy Speaker, that it takes dramas on television to try and right the scandals that have happened previously, and I just wish there was sometimes as much palpable anger in our communities to what has happened with sub-postmasters so that we could fix some of the problems that have happened with so many other scandals. But look, let's not be too critical. Today's lifting of the barriers by quashing these convictions that have happened to be able to speed up the compensation that is due to these people is something that we, of course, should applaud. And as has been rightly said across the House this afternoon, the judiciary will raise concerns. That is only to be expected. But the way I conceptualise this is that it is an unprecedented situation that requires an unprecedented solution. And therefore, there may be, quite rightly, the odd conviction will slip through the net that was warranted. But, Mr. Deputy Speaker, this situation has been going on for 15 years plus, and has been also said we must not let perfection be the enemy of good. And I think that sums up this predicament and this whole issue fairly well. To be a new MP, or not so much a new MP anymore, but to be in this place and by quite some accident able to talk about this matter with a degree of real personal feeling is something that's been a great privilege. I never expected in 2014 that I would become a sub-postmaster for a company that had purchased a supermarket with a post office in the back of it, and neither in 2015 that Budgeons of Aylsham, which was the post office that I was a sub-postmaster for, would become the best post office in the entire country. And I'm very proud of that fact, but it's meant that my speaking about this has managed to pick up quite a lot of attention. And it's been therefore a privilege to really bring to so much of the attention that's had. I bring my voice to that campaigning. And I suspect I will probably be the only serving MP to be a sub-postmaster for the foreseeable future. But what brings a lot of this home to me is it could be so easily been myself that was caught up with all of this problem. Had we have purchased that supermarket a couple of years beforehand, quite literally, I could have been suffering the consequences that so many of these men and women that we are representing this afternoon had faced. And I can still remember my stepfather wandering into my office and saying, well, you're the finance director, Duncan, you will be the nominated legal sub-postmaster. And we thought very, very little of it, other than that I was given a postman's hat at the staff Christmas party. But I remember going on the post office training courses, and without any shadow of a doubt, the people that I met were always good, decent, law-abiding citizens, the sort of people that we have seen in that documentary, in that drama documentary, and that we have spoken about so often. And every single one of us in this chamber this afternoon will have constituents, I suspect, that have been caught up with this. And the Honourable Member for North Durham talked about people being traumatised. That's absolutely true. Even in the last 3 or 4 weeks, I have sat at a lady that ran a post office in my constituency saying, Duncan, I've seen you on the television. Will you come round and talk to me? I was running a village post office. I haven't been able to sleep for years because I lost money, and I want to know whether or not I could be recompensed for that. And I have to say the Minister was incredibly helpful, immediately gave me all the links to where to go to try and help this lady. And we sat down, went through her books and records for the best part of an hour, and totted up a few of her columns. And I said, at the end of that, I said, I want you to sleep better tonight, because actually I don't think you've lost any money. I think you're one of the lucky ones, that you may have had some losses one year, but you had some gains the next, because this system just didn't work properly. Certainly, way.
I'm very grateful for the member giving way, but one of the issues which you need to do is actually try and get that message out, because I'm now getting quite a few cases where people paid money back and they weren't prosecuted, they just put it in some cases, quite a lot of money back in to keep the thing set. And I think the message that is just said about trying to make sure that they come forward to get redress is important. They feel they're not victims because they weren't prosecuted or didn't lose their livelihood. But, you know, in some cases, I've got one, for example, putting over a period of time £80,000, and those people do need redress.
Your member is absolutely right. It's the people watching this afternoon are writing up this report. Always remember that they can come forward and seek that redress, and they can get the help and support. And contact your local MP if all else fails, because most of us in this place just want to help the communities and the people that we're so privileged to represent. And I entirely take his point. I was very lucky in the case of this lady that I was dealing with. But I said to her, look, you can sleep easy tonight, because actually you are one of the lucky ones. The system didn't work properly, but just that closure, to be told that, lifted a weight off her shoulders. And we often in this place have the ability to just open the doors that people can't open themselves. And I was so pleased to be able to help. But that lady represents what we keep talking about, in that sub-postmasters and mistresses were pillars of their community. Everybody knows in their village or their town that they represent that those people were criminalised, and they were just simply not believed. And that is where the whole of this sorry period started from. I can remember in the business that I ran, the tills being down and being incredibly worried that we had lost money. But I knew one thing was absolutely for sure: it wasn't the staff that were taking the money, because I trusted them entirely. But the problem was the post office's culture. It had become a corporate beast, and it was losing its soul, I think, in the mid or early 2010s, when there was this enormous push to be a standalone organisation, to not be reliant on the government, and to sell financial products. And I can remember going on a 2016 post office conference and meeting Paul Reynolds at the time. And the irony of the conference was it was called Together. Well, it wasn't very collegiate that whilst this was going on, there were hundreds of men and women up and down the country were being convicted for crimes that they didn't commit. So the legislation may not be perfection today. There are DWP convictions, which I have taken up with the Minister, that are not included in this, and I know the reasons or his explanations why, but it still doesn't mean that I don't support what we're doing today. But I certainly want to say this, that we are not there yet, and I think this whole situation is going to run and run for still many years to come. And I say that not lightheartedly, because I think that for real closure to happen for people up and down the country, it's not just compensation and convictions being quashed, it's criminal prosecutions to those that knew what had happened within the post office but did not take the actions that they should have done. I suspect we will see that come forward in the years to come. I've said, I think, probably sort of 7 or so times in this place that Fujitsu need to face some real questions. And of course they will. They have already admitted that they will contribute compensation. But how on earth a piece of software could be written by a multi-billion-pound corporation that had a back door into it with no audit trail, where simply somebody could alter figures, is just absolutely frightening. It begs questions, as I mentioned beforehand, about the accounts for the post office, the auditors to the post office. So many problems there will never be fixed. I've also asked before many times, I want a figure of how much money was stolen from all of those innocent sub-postmasters. Nobody has ever been able to tell me what the figure is. We just watched the ITV documentary. You know, where it went even. You could add up just the figures that were taken off innocent men and women in that drama alone. But across the country, I suspect it was tens and tens and tens of millions of pounds, possibly getting even higher than £100 million. And that money needs to be identified. How much was the figure, so we actually understand the full scale of what happened here. And of course, later this year, the inquiry will conclude, and that will give us, again, finally, some real evidence of what went wrong. So look, although I've summed up and said there are still many questions to answer, we must remember that today is a very positive day for many people that are watching who were caught up with this. And I say again, place on the record, that it's nice when the House comes together. There's a great number of people in this chamber this afternoon who've done an enormous amount of good and can hold their heads very high that we've got to this place today. Thank you.
Thank you, Mr. Deputy Speaker. And can I first of all welcome this piece of legislation as well, and thank all of those in this House, the current Minister, the former Minister, and indeed the member for North Durham, who guided me through some of the issues when I first became involved in this. It's been a long battle, but I think that it's the job of this House, where it identifies an injustice, to ensure that that injustice is addressed. And this was an injustice. And I still am baffled at how we ever reached this stage. How post office officials, ministers, judges didn't question how people who had so much to lose suddenly, in their tens, turned into thieves. In fact, in their hundreds, turned into thieves. I would have thought that at some stage, and this didn't happen over a long period of time, it happened over a short period of time, this was identified. And yet, unquestionably, they were prosecuted. And indeed, some who knew the facts, because they had started going down this route, felt that they had to continue to justify it by even withholding information and pretending, oh, it's only one or two people, so others weren't alerted to what was happening. So it was an injustice. And, I've heard arguments made here today that we've got to tread very carefully this legislation, it's very delicate, and it could annoy the judges and everything else. The judges, as the member for North Durham has pointed out, were responsible as well here, because they heard evidence. Did they question as rigorously as what they ought to have done? I don't know. I don't know the individual cases, many of the individual cases, but it is quite clear that if a lot of similar cases were coming before the courts, someone should have asked, especially given that the people who were being brought to the court had so much to lose, their reputation was destroyed, and indeed, up until this point, they hadn't engaged in this kind of behaviour. I'm also not all that sensitive about stepping on some judicial toes with this legislation either. This House, on many occasions, has been quite happy in the context of Northern Ireland to overlook some of the issues, the legal issues, whether it was in exonerating or giving letters of comfort to people who have been guilty of murder, etc. So I don't really have a great deal of sympathy with the argument that, well, we've got to be very concerned and tread carefully on this piece of legislation. There are just two issues that I want to raise, and the first one is on the issue of those who have gone through the Court of Appeal already or have had their leave for appeal rejected. Given that, in most cases, the evidence which would have been presented and the judgments which have been made would have been made on the basis of, at least partly on the basis, of the trust in technology. The very thing that we're saying was wrong in the case of those who were now seeking to exonerate. I think does mean that we should be looking at those cases, and whether it's dealt with on a one-to-one basis, they should not be ignored, because the same kind of evidence is being used in those appeal cases as was being used in the court cases. And I think it would be, again, an injustice not to look at those particular issues, how it's dealt with, whether we should include the appeal cases totally, or whether they should be looked at individually. I think that we can't ignore that one. The issue, of course, I really want to address, Mr Deputy Speaker, is Clause 9, the territorial extent of this particular bill. I have heard, and I've had conversations with the Minister. I know the Minister is sympathetic. He understands the issues in relation to Northern Ireland. But when I listen to the arguments which have been made, I really don't think that there is a case for excluding Northern Ireland from the scope of this bill. Yes, justice is a devolved issue. And the Minister has, on other occasions when I've raised this with him, said we've got to be very careful of the political sensitivities. Though I've got to say, Mr Deputy Speaker, there wasn't much concern in this House about political sensitivities when we put through legislation. The number of cases of legislation, like the my arm, and they were controversial. People in Northern Ireland didn't want them taken in this House. Parties were divided about it. In this particular case, there is no division. There'll be no kickback from any party in the devolved administration. In fact, the First Minister, Deputy First Minister and Justice Minister, the three ministers who would be responsible for this, have all written to the Minister indicating that they would be fully supportive. And the reason why they'd be fully supportive is because they believe that it would not be possible to keep in step with the timing of the legislation that would go through here. And the reason for that is quite clear, that because of the way in which the Northern Ireland Assembly is obliged by law to consult on legislation. I don't even know if it would first of all have to be included in the programme for government, which would be one step, and then after it's included in the programme for government, consulted on. But even if it was only to have the legislation stand alone outside the programme for government, there's a 12-week consultation period, and as the Deputy First Minister and First Minister have pointed out, that would mean that legislation could not even be considered in the Northern Ireland Assembly this side of the summer recess. So you'd be talking about the autumn. So there's a compelling case, I think, not only because there is no opposition, but secondly because if it were to go through the route of the Northern Ireland Assembly, then it would be delayed. Yes, we'll give way.
I've heard different figures, but there's no more than 30 cases we're talking about here either. So there's small numbers, and the delay in which he is eloquently describing couldn't be justified to keep these people outside their recourse to justice.
Sammy Wilson. I think that's right. And some people may, of course, turn that argument around and say, well, it's only a small number of cases, so why should we be concerned? But while it may be a small number of cases, the thing is, since this issue has become so public, there's a public outrage on behalf of those who have been unfairly treated. And many of the people who have spoken to me about this haven't been affected personally by the Horizon scandal. But their sense of injustice, that some people were affected in this way, they lost their reputation, they lost their money, they lost their business, they lost in some cases their families, and they've lost their peace of mind. There is a need not to delay any longer if it is at all possible. And I believe that one of the ways of ensuring that there is not that delay is to include Northern Ireland in the legislation. I know the Minister, when she was asked about this, said that she wanted to avoid unintentional consequences. Now, those unintentional consequences were unspecified because we didn't get any examples of them. But I don't see how there could be any unintentional consequences from including Northern Ireland in this legislation. It's a tight piece of legislation. It specifies who is covered by it, what offences are covered by it, and the way in which the exoneration would be implemented by having records removed, etc. So I really can't see where the unintended consequences would be, and I find that argument fairly weak.
East Antrim for giving way. He's described the logistical problems here. Does he not agree with me that if the territorial provisions were extended to Scotland and Northern Ireland, all that would require is the Northern Ireland Assembly and the Scottish Parliament to provide a legislative consent motion, and that would be a cleaner and more efficient way of dealing with the issue for people in Northern Ireland and Scotland?
I'm not even so sure that in the case of Northern Ireland it would require the legislative consent motion, simply because it's already been indicated by the Executive that they'll be happy for Northern Ireland to be included. So, I mean, I don't see that it's going to tramp on any political sensitivities. It can't have unintended consequences. Now, another argument, of course, has been, but look, you know, you're going to upset the judiciary. Well, in my view, does it matter whether the judiciary are upset by a decision made in this House or a decision made in the Assembly? If they're going to be upset, they're going to be upset. I suspect that they'll not, because I'm sure that many of the judges also recognise that in light of the evidence which has now become available, that the decisions made are decisions which have to be looked at again anyway. So I don't think that there's an argument there. Another argument which has been made is that I think it was one of the members from this side who made this, that politicians in devolved administrations should take the risk and take a responsibility for the job that they're required to do. I don't mind politicians taking responsibility for things that they've been responsible for. But this was not an issue that politicians in Northern Ireland, or indeed in Scotland, were responsible for. The Post Office was not a devolved issue, it was reserved. The prosecutions were initiated by actions taken by the Post Office and by views which are put forward by... I'll get away in a minute. So, you know, to say, well, you've got to man up and take responsibility, I'm not so sure that that's an argument which stands when this is a national issue. The Post Office is organised on a national basis. The compensation will be organised on a national basis, and therefore, to me, there's no responsibility there for the devolved administrations.
I'm grateful to the Honourable Gentleman for giving way. As a matter of fact, the situation is different in Scotland. Prosecutions are taken there in the name of the Procurator Fiscal or the Lord Advocate, depending on the forum, and they receive only the report from the Post Office. So the prosecution decision is made by the prosecuting authorities. I understand that in other parts of the United Kingdom the Post Office can prosecute in their own right, but that's not the situation in Scotland. That's why it's different.
And I'm not going to enter into a debate about Scotland because I don't have enough knowledge about the situation in Scotland, but surely the way round that is to make sure that the individual who is responsible for having taken the prosecutions and for advising the Scottish Government, if they're satisfied that it should be, and that's perhaps what we should be looking at, if they're satisfied that it should be taken here in Westminster, then why don't we include it in the bill? But I'm sure the Scottish Nationalists can argue their case very, very well. The one thing I would say as a Unionist, I'm very pleased that there's a recognition in the Scottish National Party that there is a role for Westminster. And if they want to give some of their powers to Westminster on this particular issue, then I will take that as a Unionist win.
Well, I thank the Honourable Member for giving way. The fact that the Scottish Government wants this bill to go through for all four nations of the UK and that they would give a legislative consent motion for that to happen surely indicates that in this case, as the Honourable Member for East Antrim has already said, this is an issue that rose here and should be sorted out here. And in Scotland, and in England, there are issues of prosecutions by the CPS in England, not just in Scotland. It wasn't all post office prosecutions that we are exonerating, or this place will exonerate this bill on.
Mr Deputy Speaker, I'm not going to become a spokesperson for the Scottish National Party on this particular issue. I'm arguing the case for Northern Ireland, but I also believe that there's a parallel. And the one thing that I would say in all of this, and I know that there will be differences, and we have heard the arguments back and forward today as to why Scotland might be treated differently than everything else. There's a sour taste in people's mouths because of the injustice that there was over the Horizon scandal. Let's not let that persist. If there's a way of sweetening the issue, if there's a way of dealing with the issue and dealing with it in a respectful way which impacts on everybody and ensures that those who have had this cloud hanging over them can be exonerated, and who have lost out financially and in many other ways, they can be sorted out. Let's do it. Let's do it quickly. Let's do it fairly. And let's ensure that we put this injustice behind us as quickly as we can.
Alistair Carmichael.
Thank you, Mr Deputy Speaker. It's a pleasure to follow the honourable gentleman from East Antrim. He says he's proud as a Unionist to see that this is a decision being taken here. I say to him gently, be wary of Scottish nationalists bearing gifts of UK accountability, because essentially that's where we come to here today. I'll pick up the point about territorial jurisdiction later on, but I do want to say a word or two, first of all, of more general application. A lot of people in the debate today so far have spoken about this being unprecedented, and they've spoken about the concerns of some in the legal profession and the judiciary about the discomfort that they feel. I think these feelings of discomfort are entirely appropriate and legitimate. I think I would be more concerned if they were not there. But it is because of the wholly exceptional nature of the situation facing those who were prosecuted as a consequence of the deception of the Post Office, Fujitsu, and the misuse of the Horizon software that we should have a bill of this sort. And I and my colleagues on the Liberal Democrat benches have no difficulty in supporting the bill. To those of my former colleagues, I should declare an interest as a recovering solicitor myself. It's 22 and a half years since I surrendered my practising certificate, no doubt to the relief of many. But I would say this, it's worth just asking ourselves, why do we have courts in the first place? And essentially, we have courts because it is important that there are bodies that are able to give the general public confidence that the various vehicles of the state work properly and that people can get justice. Do they get it right all the time? No, of course they don't. When I was a solicitor, we often used to say justice has to be seen to be done, and it often has to be seen to be believed. So let's not forget that the judiciary, like the rest of us, if they are cut, they bleed, and that they are vulnerable to the same human foibles as the rest of us. They have then ultimately to be accountable for those at moments like this. And those who've said that the judiciary do need to take a look at themselves, I think, are right to say that. I take mild exception to the suggestion that somehow or another the doctrine of the separation of powers builds an impenetrable wall between the different legs of the Constitution. It doesn't. This House actually created the very institution of the Supreme Court barely 20 years ago. We interfere all the time in the running of the courts by setting their budgets and by telling them what rules of procedure and evidence they can follow. Nobody takes exception to that. Now, of course, what we are dealing with here today is an interference of a different order altogether, but it is one which is conformed to those principles that there are occasions when this House, as a sovereign Parliament, has to act and to intervene, and I think that the nature and scale of the injustices that have been visited upon people here absolutely justify that. The question about territorial jurisdiction, I think, is an important one. I listened very carefully to the Honourable Lady from Motherwell and Wishaw, who incidentally I rate very highly, at the risk of just killing her political career stone dead, but by praise. I've got enormous respect for the way in which she has managed the all-party parliamentary group and post offices, and the very measured and effective way in which she has prosecuted the case for postmasters, sub-postmasters, post office employees, not just in relation to the Horizon scandal, but in fact in the day-to-day operation of the post office itself. And it pains me to find myself in a different place from her. I said to her last night that I'm still open to be persuaded on this, but my starting point has to be that we judge this by the outcomes for the postmasters themselves. And essentially by that, I mean, can we get to the same place for them in Scotland by allowing the Scottish Parliament to do their job constitutionally that they are charged to do, or if it is something that in order to get to that same place for everybody at the same time, we have to do it here. Of course.
I'm very grateful to the Right Honourable Gentleman for giving way and to kill his political career. I have the same respect that he has for the Honourable.
I have no political career.
Motherwell and Wishaw. This is a debate, as he has said, is about how best we can get justice to the victims. Can I offer him as one of the solutions which is actually happening now, which is in the Criminal Justice Bill, which has not reached all the stages of the parliamentary process, already has legislative consent motion from the Scottish Parliament for those areas of the bill which impact on Scotland, and that is perhaps a way of getting round the territorial debate, is that if Scotland and Northern Ireland are put there, it would allow legislative consent both in Northern Ireland and Scotland to happen concurrently at the same time as the legislation is passing here.
In terms of procedure, that is one way that it could be done. But I think what I would say to the Honourable Gentleman and to his Honourable friend is that this question of quashing convictions is just one element of justice here. Yes. And the other very important element of justice in relation to prosecutions is that those who were responsible for initiating these prosecutions have to be accountable. So it is that element of accountability that would be missing by putting the provisions for Scotland in this bill, or indeed the Criminal Justice Bill. And I think that for the quality of justice, that accountability, if it is achievable within the same timescale, because we are balancing competing demands here, is very important. Now, the position in relation to Northern Ireland, I'll take it in a second, is different. It's qualitatively different because they have a statutory requirement for a 12-week consultation. The Scottish Parliament does not have that requirement, so they would be able to proceed. I'll give way to the Honourable Gentleman.
I'm grateful to the Honourable Member for Orkney and Shetland for giving way. And I apologise for not being here at the beginning. I was chairing the Energy Committee. But the other leg of justice that has to be served is the compensation leg of justice. And I'm sure he was probably coming on to that anyway. But it's not just to those who were convicted. There are a lot of people out there who paid money to the post office to keep the heavies away. Yep. They dipped into their own pocket to keep the heavies away to prevent prosecution. And those people also need to see justice. And one of the big things we've got to see here is moving this legislation forward so it all happens and the money gets to the people.
The Honourable Gentleman is absolutely right. And indeed, I think if he's been listening, he will have heard me speak on a number of occasions in relation to the work I've done to support constituents who are pursuing claims as part of the historic shortfall scheme. Yes. And that would be the route to compensation for the people to whom the Honourable Gentleman refers. But we have taken a particular approach here quite deliberately, and I think for good reason. So when it does come to the question of compensation, because the Post Office is a function that is reserved legislatively to the United Kingdom Parliament, it is a United Kingdom operation, then obviously the compensation, when it is to be paid, should be done on a UK-wide basis. The decisions to prosecute, however, were ones that were taken in Scotland. They were taken by law officers who are accountable to the Scottish Parliament, and for that reason I think it makes sense for the Scottish Parliament to deal with the consequences of these prosecutions. Of course, I agree.
I'm grateful again, and I just put it to him, I don't necessarily have the answer, but I think this is the problem within this, is if the Scottish Parliament quashes that, there could be a hiatus before the money arrives, waiting for Westminster to go and do something. So we have probably a very genuine chicken and egg situation here. I would much prefer the Scottish Parliament sorted it, I much prefer the Scottish Parliament had the resources to compensate, but that's not the world we live in, unfortunately, in the UK.
I don't think it's unfortunate. I think it's highly fortunate and it's deliberate that we're in the UK, but we'll save that debate for another day. But on the point of the compensation can be and will be paid on a UK-wide basis. But that is, well, on the timescale that has been outlined by the government so far, we would expect the convictions to be quashed on the basis of the bill that the House is considering today by the middle of July. Now that gives the Scottish Parliament time to meet the same timescale so that the victims in Scotland would also have their cases quashed by that time. I would hope... yeah, of course.
Very grateful to Evening Way. He's making some very important points about the way the prosecution systems work in different parts of the UK, which we must take into account. Just in terms of the point about paying redress, which is that the Honourable Gentleman refers to, the key thing is overturning the conviction. Wherever in the UK that conviction is overturned, gives that individual, once that is overturned, immediate access to the redress scheme wherever they are in the United Kingdom. So there is no hiatus as he describes it.
Yes, I'm grateful to the Minister for that. Those who are not convicted will have access to compensation through the historic shortfall scheme, and that is a process that is available to them at the moment.
This bill only relates to overturning convictions, and there is a discussion about territorial extent, which I understand and happy to continue to discuss. The compensation schemes, whatever schemes there are three: Horizon Shortfall Scheme, Group Litigation Order Scheme, and the Overturned Conviction Schemes, are all UK-wide. So whatever detriment is experienced wherever they are in the UK, there is no delay to compensation. There's no difference in terms of compensation from one part of the UK to another, and that we're keen to expedite it wherever it is in the UK, and we've got work to do.
I don't really need to answer that, so yes, I will take the honourable lady.
I thank the right honourable gentleman for taking that point. One of the issues about timing, and it is about timing, and I think everyone would agree that it's best that every victim is exonerated at the same time. Mm-hmm. But if, as we don't have the programme yet of timing for the third reading, for the committee stage, it is possible that the Scottish Parliament could be in recess, and it will be in recess as early as the 29th of June, a full month before this place.
Well, I mean, that's a political decision for the Scottish Government in control of the Scottish Parliament business to take.
Can I just, I think, gently correct the right honourable gentleman? The recess dates are not set by the Scottish Government. They are set by the Parliamentary Board.
They're set by the Parliamentary Bureau, the majority of members which come from the SNP and the Greens. Now, I've kept this fairly broad in its terms. Can I just say gently to the Honourable Lady, if the Scottish Government, instead of trying to evade political accountability, would take their responsibility seriously and get on with it, get on with the drafting of the necessary legislation. If they want to wait and see how it all works here, to see if there are further amendments, then of course they can do so. They should be mindful of the fact, of course, that apart from this one point, on the substantive provisions on this bill, there is complete unanimity across all the parties of the House. So I would not see this as being a bill that was likely to attract amendment on the substance. If the Honourable Lady wishes to bring her amendments at a later stage in relation to jurisdiction, then that's another matter altogether. Of course, if we consider the consequences for that, for the substance of it, we would effectively be writing a whole new part of the bill, because if we have regard to the offences, for example, for which a compensation is to be paid, very few of these offences are terms of art in Scots law. So we would be writing a new bill to be inserted in here. Why is the Scottish Government so resistant to getting on and doing what they are constitutionally charged to do, when they can do it if they start now in a timescale that brings everybody to the same place? The Honourable Lady herself said that compensation had to be done equitably and fairly. And I put to her and to her colleagues today that actually the consequence of what we would have if their route were to be followed is that Scottish victims would have a justice of a lesser quality, because the decisions about prosecution are accountable to this House in England. There would be no such accountability for the decisions in prosecution if they were to be taken in the Scottish Parliament. Can the Honourable gentleman who's sitting to my left here saying it's not true explain to me why he's saying that?
Well, I'll do that, and I'm always to his left, as he knows. But can I say to him that if the Parliament discusses legislative consent, that's where that accountability takes place. And I would say to him again, he doesn't need to answer it today, because obviously we're going through other stages, and the Minister said he's considering it, but I do hope that he'll consider the Criminal Justice Bill example and legislative consent as being a solution to the issue.
It is a solution to the issue in as much as it's another means of doing the same thing that his party wants to do in respect of this bill. It's not a solution to this issue in as much as it allows that level of accountability. And it is the accountability that matters here. The Lord Advocate, the current Lord Advocate, Dorothy Bain, has already said on the record, not every case involving horizon evidence will be a miscarriage of justice. Each case must be considered carefully and with regard to the law. It's also important to recognise, as others have said here, the important constitutional role of the appeal court in Scotland. Due process must be followed. Now, that is a qualitatively different approach from the one which is at the heart of the bill here today. She might be right, but that is where she has to explain herself. She also has to explain the decisions that were taken by her predecessors. I mean, it's 30 years ago now, but I did start my legal career, meagre and modest though it may have been, in Crown Office in Edinburgh. Eilish Angelini, who we were feting here just a week or two ago for her work in relation to her report into the workings of the Metropolitan Police, was my first boss when I was a trainee solicitor in Crown Office. My second boss was Frank Mulholland, who's now Lord Mulholland, and he was the second Lord Advocate who would have had responsibility for some of these cases. They will all have to be accountable in their own way. The Lord Advocate, the current Lord Advocate, will be accountable. And I think she obviously, from the statement she gave to the Scottish Parliament, is already fairly well advanced in this work. She's confirmed that the Scottish Criminal Cases Review Commission have written to 73 potential victims of the Horizon scandal in 2020. Crown Office have identified another 54 cases which are being reviewed by prosecutors, and many of those cases have been contacted by the SCCRC as well. As of March 2024, 19 people have come forward to have their cases reviewed. 8 of those have been referred to court, 6 having their cases cleared. The remaining 2 are still pending outcome. So, given the amount of work that has been done, given the nature of what the Lord Advocate has said on the record, it makes, to my mind, absolutely no sense for the Scottish elements of this one narrow part. The decisions to prosecute should be taken differently. It does come to accountability, and surely, if we've learned nothing else throughout this whole sorry episode of the Horizon scheme and Post Office Limited, surely we have learned that accountability at the end of the day makes a difference.
Thank you very much, Mr. Deputy Speaker. It's a pleasure to follow my right honourable friend from Orkney and Shetland. I want to return the conversation back to Northern Ireland, but only briefly, because we have aired the issues, I believe, reasonably well during this debate. Before getting there, I just want to put on record my own and my party's welcome for this legislation, and to thank the Minister for the Post Office for the work that he's done so far in this regard. We certainly recognise that this is a highly exceptional situation which justifies the approach that has been taken. I'm not certain that we'll never face a similar situation sometime in the years and decades ahead, but it is something that does warrant the approach that has been taken, because frankly this is about exoneration, and concepts around pardons and something else don't quite fit the bill in terms of what has happened here. The record needs to be entirely clear that prosecution should never have taken place, and that any conviction entirely vacated, rather than simply a situation where someone goes through an amnesty or a pardon, but there's still that sense that something wrong happened prior to that. I want to thank the Minister for his ongoing engagement, specifically around the issue of Northern Ireland, conversations that I've had with him. I'll also put on record my thanks to the opposition front bench for their comments during this debate, that they are open to the inclusion of Northern Ireland within this legislation. I essentially want to briefly touch upon, essentially in summary, the case for Northern Ireland as to why we believe that action is warranted through Westminster in this particular regard. This is essentially a UK-wide scandal, and it requires a UK-wide solution. The Post Office is not reserved. It is a UK-wide responsibility. So the issues that have come about were not in the gift or control, or something that the devolved administrations could ever have regulated or sought to prevent, even if they had the foresight to identify the problems that were emerging. The difficulty now is, if we end up with Northern Ireland left to act separately in this regard, that we will see further injustice emerge. The Executive is just restored, and they have other priorities at present in terms of getting up and running. But even in the event that the Assembly was fully functioning and had been functioning for quite some time, this process does require in practice a public consultation in terms of how business is done in Northern Ireland, and not to do so would pose a ongoing risk of a judicial review, which would further complicate and probably actually further elongate the process further, and that would be counterproductive. So the public consultation has to be priced in that regard. It takes time to draft. Obviously, the Department of Justice can look to what's happened in terms of England and Wales, but there still would need to be a minimum of 8 weeks, in practice probably 12 weeks of a public consultation. That then has to be evaluated, and legislation then tabled in the Assembly and go through its own process. With the best will in the world, I don't see how this process could be concluded until well into the autumn of this year, and potentially it could be longer than that. That will create the situation where we have some of the victims of the scandal in terms of false convictions waiting for justice longer than their counterparts everywhere else in the UK. But also, given that exoneration is the gateway to compensation, they would be further penalised in the sense that they would be doubly delayed, not just in terms of their exoneration, but also the access to that compensation. So natural justice leans very heavily in terms of this administration in London taking the action for Northern Ireland. And again, like the member for East Antrim, I want to stress the scale of the political consensus on this in Northern Ireland. It is something that is rare, but it is something precious whenever it does emerge. And there is the sense that we want this done as quickly as possible. We want to be pragmatic around it. And insofar as anyone has any sense or notion that they are treading on devolved toes by acting in place of the Executive and Assembly, I want to just utterly dismiss that notion. The parties want this to happen right across the political spectrum. So there won't be any political blowback in terms of action being taken forward in this particular regard. Obviously, this has to be done on a case-by-case basis, but in this particular situation, and not least given the extraordinary circumstances, I think there is an overwhelming argument for Northern Ireland being included. And I look forward to any comments that the Minister can give in terms of his summation shortly, but also some indication if he will be willing to accept amendments later on in the process at committee stage, of course subject to the proper motions being put in place to facilitate that in terms of the legislation as currently drafted. So thank you very much, Mr. Deputy Speaker.
Ali.
Thank you, Mr. Deputy Speaker. We are now over 2 decades into this scandal, with the victims still suffering the ongoing consequences of this injustice. Unjust prison sentences, bankruptcy, ostracisation from communities, family breakdown and homelessness. And tragically for some, as we've heard, this scandal has led to them taking their lives. As of the 10th of August 2023, according to the Post Office Horizon IT inquiry, at least 60 sub-postmasters have died without seeing justice or receiving compensation, and at least 4 took their own lives. All our thoughts continue to be with their families. Mr. Deputy Speaker, this scandal has been a seismic tragedy at every stage. The mental toll and stress victims have faced is beyond what many of us can begin to comprehend. This scandal has been defined at every turn by abuse of power, disregard for sub-postmasters' lives, the passing of blame and perpetual delay. This bill is an important step forward in addressing the greatest miscarriages of justice in our country. It will mean hundreds of innocent victims will have their rightful innocence returned to them. However, this is one of a number of actions that need to be taken to make amends to correct this terrible injustice. It means we need to see convictions quashed, compensation delivered urgently, and justice sought from the independent inquiry. I want to pay, along with other colleagues, tribute to Alan Bates and the many sub-postmasters who have campaigned and worked tirelessly to seek justice. This bill marks an important victory for sub-postmasters, and I pay tribute to the bravery and perseverance in the face of so much suffering and adversity. They have had to take on so much, have had so much taken from them, and yet they've kept fighting. And this is truly remarkable. And it's wonderful to hear the tributes that have been paid by so many across the House, but also across our country. I want to pay tribute to my honourable friend, my right honourable friend, the member for North Durham, for all his work fighting on behalf of sub-postmasters, and Lord Arbuthnot for his years of work in tackling this injustice. I also want to thank the Minister for Postal Affairs for all his work, both from the backbench as well as from the front bench. There have been many members across the two houses, who have highlighted the injustice suffered by sub-postmasters, and I want to extend our appreciation from this side of the House for the work that they have all done and the cross-party nature of the campaigning that has gone on thus far. I think we can all agree that the influence, as has been said before, of the ITV drama Mr. Bates versus the Post Office has been very significant in this campaign. And while the Minister has done a huge amount of work, there's no denying that that programme has brought to the attention of the wider public the scandal that has affected so many sub-postmasters. But, Madam Deputy Speaker, it should not have taken the release of this drama to get to where we are today. And this is not in no way a criticism, it's a recognition of the fact that certain scandals have needed that wider attention from the media, from the contribution from programmes like this one before and documentaries before attention is received. But we are where we are, and it's encouraging to see the steps that have been taken. This bill will quash the convictions of the sub-postmasters and others who worked in the post office branches who suffered as a result of the Horizon scandal. As has already been said, and I would like to further stress, the quashing of these convictions does not set a precedent, must not set a precedent. This bill undermines a key part of our democracy, which is the separation of the legislature and the judiciary. As has been said earlier in the debate, it is a constitutional anomaly. We must, as has been recognised, understand the weight of this so that such action is never considered again. The legal solution of this bill is a wholly exceptional and isolated case where these necessary actions will be taken to match an unprecedented miscarriage of justice in both scale and impact. And as my honourable friend, the Shadow Business Secretary, has made clear, an incoming Labour government would never use this kind of action again. I would also like to echo the comments on the territorial scope of today's bill and restate that the Labour Party supports the calls to extend the provisions of this bill to the cases in Northern Ireland. Every party in Northern Ireland, as has been stated in this debate, and every minister in the new Assembly is calling for their inclusion in the bill. Their exclusion will sadly only delay exoneration of victims in Northern Ireland all the more. So I hope the Minister will seriously consider this decision and what can be done further, and take on board the points that have been made by honourable members, as well as my honourable friend, the Shadow Business Secretary. Madam Deputy Speaker, we've heard a lot of very powerful contributions today in the debates, and the broad agreement for the need for, the necessity for this bill. The Right Honourable Member for Haltemprice and Howden highlighted his misgivings about this bill and described it as representing the best of a bad situation, although, of course, extending his support. And he highlighted the unprecedented nature of it. My right honourable friend, the member for Birmingham Hodge Hill, made the case for speed in settling the granting of compensation. My right honourable friend, the member for North Durham, raised important concerns about the potential limitations of setting deadlines for the government on paying compensation. I hope the government, on paying compensation while ensuring that there is proper handling of complex cases, will take those points into consideration. He also raised important points about the need for the judiciary to learn lessons and for the government to learn lessons from this scandal, so that we can ensure that there are broader lessons that can be applied where other scandals are concerned. In the debate, throughout the debate, a number of other scandals have been mentioned: the contaminated blood scandal, the Windrush scandal, and others. And it's encouraging to see that there is a real eagerness to reflect and learn, so that we do not have a situation where things have to come this far before these matters are addressed. The member for Motherwell and Wishaw, who's been a tireless advocate and campaigner for justice for sub-postmasters, has rightly highlighted the need to continue a laser-sharp focus on supporting victims. And she relayed once again, along with others, in her party, about the concerns of Scotland being left out of the bill. An extensive debate that has been taken place between different members. The Honourable Member for Sutton and Cheam, the former Minister, spoke powerfully about his time as the Postal Affairs Minister. And as he's standing down, I want to commend him for his work in his capacity as Minister responsible and the work he did during his time in the department, but also his wider work working across parties on a number of issues, including in relation to Myanmar with me and many other colleagues. And we wish him well in his future endeavours when he leaves the House. He raised the need for learning the lessons, as others have, and ensuring that when we say this must never happen again in relation to scandals of the scale of what we've seen and others, that we truly can say and make sure it doesn't happen again. The Honourable Member for Norfolk spoke powerfully about his own career as a former sub-postmaster and the insights he brought to this debate and the campaigning, and reflected on the trauma that his constituent face and the way in which he has got involved in supporting his constituent and drawing those lessons into the work that has been carried out but with the department, with the Minister. What struck me was the way in which he reflected on the wider issues to do with the Post Office. The Post Office culture, which needs work in terms of tackling the wider issues, systemic issues. The term he used was losing its soul. I hope that as we look to the future, the government will look at how we make the necessary reforms so that it is fit for purpose. He raised rightly the point about Fujitsu and the need for holding them accountable, including compensation. While this is outside the scope of this bill, the important work that the Minister and others need to do to make sure that they pay for what was caused by their technology failures. Madam Deputy Speaker, the Honourable Member for East Antrim made the powerful case for, once again, those whose appeals have been rejected and argued that these cases need to be looked at again. And I know that the Minister has responded earlier on and will look at these issues closely. He also made the point about territorial scope and reinforced the need for Northern Ireland to be included in the case, in the bill. And in particular, the point that's been made consistently about the 12-week consultation, which means that Northern Irish cases, the 27 or 30 cases of those who are affected, will face huge delays. And that means further suffering. And therefore, it's important for the government to consider including, as we have called for as well, including Northern Ireland. The Right Honourable Member for Orkney and Shetland made the case for the Scottish Government introducing legislation in parallel in Scotland. Much work has been done in Scotland and the case for needing to work in parallel in lockstep to make sure that there are provisions in Scotland. The Honourable Member for North Down spoke about prosecutions that should never have taken place, and once again made the case for Northern Ireland being included and the need for avoiding delay. Madam Deputy Speaker, we've heard many powerful testimonies of victims who said they lost decades of their lives to this scandal. Katie Downey, who set up the group Lost Chances for the Children of Sub-Postmasters, a group to support the children of some of the victims of the scandal, said that when her father was made bankrupt from the scandal, she was 11 years old and her family had to flee to France. Ms. Downey stopped speaking for 2 years as a result of the trauma. Her childhood was shaped by this injustice. We must not forget the wide-reaching impact of this scandal on family members. There are children, spouses, parents, close friends and neighbours who have not only journeyed with the victims but suffered themselves and lived out the unjust consequences of this injustice. Seema Misra was jailed on her son's 10th birthday while she was pregnant after being pronounced guilty of stealing £74,000 from the post office she ran, wrongly accused. Ms. Misra and her husband had been trying for a baby for 8 years, and what should have been one of the happiest moments of their lives became a nightmare. She was put under suicide watch in prison and describes herself as reaching complete rock bottom. These are only two stories of the horrors that have defined the lives of victims. So today I want to thank colleagues across the House for powerfully sharing the examples of the cases they have dealt with, be they constituents or those that they've come across through their campaigning work, and for the tireless work they have done in advocating for them and telling their stories and talking to ministers and persisting. Their stories and voices must be central in shaping our next steps and the pursuit of their compensation, the pursuit of justice and exoneration. So today we welcome this crucial piece of legislation, but this is by no means anywhere close to an end point, but merely a further step in the right direction for securing justice for sub-postmasters. We support the work of the independent inquiry in uncovering the full and precise truth of all that has unfolded in the Post Office. Truth and justice has been denied to sub-postmasters at every turn, and I hope this inquiry will finally provide the transparency that is desperately needed. There is much still to be done in the pursuit of justice for sub-postmasters, and we must all continue to support them and do all we can to right the many wrongs they have suffered. Thank you.
Before I call the Minister, can I just remind those who've contributed to the debate that it is very important to get back for the wind-ups, including for the beginning of the opposition shadow minister as well. Minister Kevan Hollinrake.
Well, thank you, Madam Deputy Speaker. And for members of this House, for the wider public and most of all for the victims of this horrendous scandal, this day could not come soon enough. And the day that the convictions are finally quashed cannot come soon enough. And the day that redress is finally paid and those victims can get on with their lives cannot come soon enough. This bill will quash relevant convictions of individuals who worked, including on a voluntary basis, in post office branches who have suffered as a consequence of the Post Office Horizon IT scandal. It will quash on a blanket basis convictions for various offences of theft, fraud and related offences during the period of the Horizon scandal in England and Wales. This is an exceptional response which recognises the constitutional sensitivity and unprecedented nature of this situation. The Government is clear that given the factually exceptional nature of this case, this legislation does not set a precedent for the future relationship between the Executive, Parliament and the Judiciary. The scale and circumstances of this prosecutorial and investigatory misconduct means that to deliver long overdue justice, this rapid approach is needed whilst respecting the separation of powers and delicate constitutional balance. It is some years ago that I first spoke on this matter from the backbenches, and indeed it was in the context of other scandals involving banks, RBS and Lloyds, when a gentleman called Paul Marshall, a barrister involved in these cases, first wrote to me and drew the parallels between this and the cases relating to the banking scandals. Indeed, it was back in March 2020 that I first spoke about this issue and Lee Castleton's tragic cases. So for the scale of the injustice, the depth of the damage and the despair, the unacceptable delays in delivering justice, we must act in this exceptional manner. If I can touch merely in my speech in terms of the points that have been raised by various contributions in this debate. First, the Shadow Secretary of State and the Shadow Minister. Can I thank them both for their collaborative approach in terms of this particular issue? And can I also join them in thanking my predecessor, or not my direct predecessor, but a couple before that, the my honourable friend, the member for Sutton and Cheam. He did a tremendous job. We all wish him well in whatever he chooses to do in his new life, but I should remind him he has work to do in this place yet, because we have much work to do. I can just gently push back a little bit, as I did earlier, on the Shadow Minister in terms of it was a TV drama that stimulated the work that has gone on today and in previous weeks. Of course, we are public servants, and of course, we should respond quite rightly to public outcry. And I welcome the new attention that's been focused on this issue in the wider general public, in the media, and in this House. But just to remind everybody across this House, and most importantly to victims at home, that we put in place many measures to try and deal with this, not always as successfully as we'd like, not all which should proceed as quickly as we'd like. The Rise and Shortfall Scheme in 2020, the inquiry started in 2020, the Group Litigation Order Scheme for Compensation Scheme, the Rising Compensation Advisory Board, which my right honourable friend, the member for North Durham, sits upon so effectively. The Fixum Awards last autumn, £600,000 for those that overturned convictions. The exploration of how we might overturn convictions more quickly began some months before the TV dramatisation came to our screens. And indeed, the compensation bill that we passed in December to set aside the deadline date that was going to prove a difficulty for some of the victims. The Shadow Secretary of State points to the service level agreements you might put, which I think responds to some of the issues raised by the Select Committee in terms of timeliness of compensation. As he knows and as she knows, there are service level agreements, if you like, and the current compensation on the Group Litigation Order Scheme will respond to 90% of final claims submitted within 40 days. We're hitting 87% against that particular metric, so we're making progress. It's something we are certainly considering in other elements of the schemes, the new scheme and other schemes, so it's something we will definitely come back to this House with. He raised the point, as many other members have, in terms of the issue on Northern Ireland, and we are taking this very seriously as members have described it. We are sympathetic to these issues, particularly around the fact that the Assembly is newly formed, a new Assembly has just been formed, and the requirements of public consultations in that jurisdiction, which may delay things, something we will certainly bear in mind in our deliberations. The Shadow Minister, quite rightly, raises the point about the impact not just on the victims, but the victims' families, their children, their spouses, and indeed, terrible things have happened to many of those families in terms of breakups, suicides. We know we've all witnessed on our TV screens the extent of this problem. We are certainly looking at things like mental health support for those individuals affected in that way. My right honourable friend, the member for Bromley and Chislehurst, right honourable and learned friend, talks about a sunset clause. Interesting that following his intervention on a sunset clause, there were 3 other legal opinions on the similar matter, which didn't all agree with his point. I think the key thing about this is all convictions are quashed the day this legislation comes into effect, which should be in July. So, irrespective of the fact whether we may have not identified somebody who in the people we write to following the passing of this bill, their conviction will have been quashed. If they come forward and self-certify and we look at their case, that conviction won't be quashed, will have already been quashed. We'll just need to mark the record. The Honourable Gentleman, member for Shetland, Orkney and Shetland, talks about political accountability, which I'll come back to, and he raises some very important points. The right honourable friend, the member for Haltemprice and Howden, talks about this matter should have been dealt with in the courtroom, and I think we'd all prefer to see that. I've described this in the past as the lesser of two evils in how we deal with this. We've got to acknowledge of the 983 convictions, the first convictions were overturned in 2021. Thus far, only 102 convictions have been overturned. That's a pace of progress we just cannot countenance. So that's why we've taken this particular approach. But I thank him for his kind words on my work, but I would reiterate that the Secretary of State has been hugely supportive of everything I have been asked to do and wanted to do in this space, and so has the Prime Minister and the Chancellor of the Exchequer and many other ministers right across government. The Honourable Lady, the member for Motherwell and Wishaw, which I have a great deal of time for, and we spend a great deal of time together actually in terms of working on this particular issue, and her work on the APPG on the post office is invaluable. I fully understand her points about Scotland in terms of she wants to make sure that her legislation is simultaneous to this legislation. We believe that can happen in Scotland. We do believe there are not barriers as such with Scotland in the way there potentially are with Northern Ireland. We also bear in mind the Lord Advocate there has tends to have a different opinion in terms of whether this is the right way to go about it. When we've taken this route, we have made difficult political choices. One of the political choices we've had to make, of course, is to exclude cases that have been heard by the Court of Appeal. That's the decision we had to take here. Very difficult choices, and I think the point about political accountability is very, very, very important. So that's why we've decided to use this objective criteria route. Her objective criteria would have to be different. For instance, it's a different prosecutor, so it couldn't be identical legislation. So there are some differences, however way you want to look at this. I'm sure this debate will continue, of course. I think the Honourable Gentleman around there.
Minister for giving way, and the Minister knows that there's huge admiration for the way in which he is taking this and trying to wrestle us through these issues. At the end of these proceedings, I intend to lay an instruction to the House motion. Now, is that necessary? Can the Minister tell us now that he will actually take this on and include Northern Ireland in this bill?
I cannot tell. I understand his point. I can tell him at this dispatch box that it's something we will continue to have dialogue with. I've talked to his colleagues today and yesterday. In fact, I met with his First Minister and the Deputy First Minister yesterday and the Justice Minister yesterday to discuss these points. There are some interesting points that we need to take into account. I'm very happy to keep these conversations ongoing. So very happy to have a further conversation with him after this particular debate. Happy to give way.
He's showing his customary politeness and kindness. The discussions he's outlined with Northern Ireland, is there also discussions with the Scottish Government? Because the main issue here really is how we get a solution that satisfies everyone across these islands. And so will he also have that discussion with the Scottish Government, particularly around territorial, and could he also say something about Aslan Scotland employees who are caught up as well?
Yeah, I'm absolutely giving the assurance. We want to see everything happen simultaneously. That's what we would like. Our ambition is to get this legislation passed by July. If we do that, because of the rapid way we can pay compensation, if people choose a fixed sum award route and they have two choices of route to take, but the £600,000 can be delivered very quickly, literally within weeks of passing this legislation. So from July, we want to pass this legislation. In August, we can be paying compensation that quickly. So, and exactly the same can happen in Scotland if they affect the legislation at the same pace. We are working on a weekly basis, my officials, with his officials, his government's officials, to try and make sure that is the case. And I've certainly engaged with, his government, the SNP, the government, the SNP leads in Scotland's officials. And so I met with his, my counterpart in the Scottish Government to talk about this particular issue. I didn't quite get his point. I think he talked about employees of employees. You might want to intervene on me again so I can address his point properly.
Sorry. It was in relation to a number of members have mentioned, as I have, about employees in Asda and Scotland, and there is a particular issue there, whether he's thought about that during the debate.
Well, we know employees generally are an issue around this, although I said earlier that because they have a contractual relationship with the Post Office, which is required to enter the compensation scheme, but the company itself could make a compensation claim, which could then be passed on to the individual. Very happy to discuss any individual cases with him or with other members of this House. Member for Sutton Cheam pay tribute again to all his work, and as he says, this is a case of human failure. And I agree with him there, as well as technology failure, and the wheels of justice are moving too slowly, and that's why we've stepped in this way. Grateful always for the work of the Right Honourable Member for North Durham, not least on the Horizon Compensation Advisory Board, makes some very important recommendations which we have adopted. He describes me he gives me a four-legged analogy in terms of person I am. He calls me more Shire horse than show pony, which I take as a compliment. But I would describe him in a four-legged way as well. It's something of the cross between a terrier and a Rottweiler, and I think he's highly effective in terms of the way he approaches this particular issue. He asked about the treatments of convictions relating to pilot versions of Horizon. That's why we've set the date at 23rd of December 1996. That's the first point of rollout of an application called Pathway, but still a Horizon application, a predecessor. So we think it captures, if I can use that word, it includes those cases with the pilot schemes within this legislation, and therefore within the redress schemes, and as it relates to in Clause 8. In terms of the capture system, as he knows, we look at this slightly differently. Horizon is a standalone spreadsheet rather than a network computer system. There is no remote access, for example. I think the key thing is here, what we're doing here is exceptional, unprecedented, and I think we have the body of evidence because it's been before a court. And part of the reason the court made the decision it did back in 2019 was based upon the Horizon issues, as it put it. We don't have that body of evidence with capture. We are keen to talk to him to make sure we do look at the evidence, and that's a conversation that will continue to go on in terms of that discussion. In terms of consequential provisions, he talks about, we don't see that as being given the ability to include another group of people within, because there are different reasons why it's in there. It's matters that are a consequence of this bill, which we don't think that would be the right vehicle to include people, for example, who have been affected by the capture system. But as I say, we will continue to discuss. Northern Ireland, as I said earlier, we think there are understand the arguments, and we'll continue to engage in those arguments, as we will with other members of this House. In terms of reasonable steps, we think we've got this process in development. The reasonable steps we need to take, this is about marking the records, writing to the individuals. At the point in time when we pass the legislation, we will then write to all the literally that day or the next day to write to those individuals to say your conversation has been quashed, and we'll give them details about how to claim compensation. Happy to give way.
I know the Minister's commitment to make sure that everyone gets contacted. Could you just talk about legacy cases, people who have passed away, because that I think will create some difficulty trying to contact their estates, for example.
These are challenging issues, of course. The key thing here is, and I hope he takes this in the right way, this does not require, what we're doing here does not require people to come forward. So in terms of quashing the conviction. When the conviction has been quashed, of course, we will contact, obviously, they will contact the most relevant person with that context. Those people in that context can take forward a claim in exactly the same way, which will be considered exactly the same way as any other claim. So the estate, the families, for example, can claim compensation. Happy to give way.
I agree. I just think we perhaps need to give some thought. It might be something the advisory board looks at about those legacy cases where people have passed away, because some of them people might not come forward for those compensations when they're entitled to it. So it's perhaps a further discussion we need to perhaps look at.
Very happy to look at ourselves and very happy to work with him on the advisory board. Can I take the opportunity to pay tribute to him, but also to Lord Arbuthnot, to Chris Hodges and Professor Richard Moorhead in the work they have done on this in this particular area, and will continue to work very closely alongside him. The honourable friend, the member for North Norfolk, recognises the work of others other than me in this, quite rightly, and not least the Secretary of State, Prime Minister and Chancellor. I recognise him, and he's the only serving postmaster in this place, and so we always listen very carefully to what he says. And we do, like him, want to encourage people to come forward to claim compensation. The people who are not included in this legislation, people who have been convicted due to taking forward prosecutions by the DWP, can still appeal in the normal way. And so we'd encourage them to do that if they feel there are grounds to do that. He asked about Fujitsu and the quantum they're due to pay to this, and I think our view has always been that we should let the inquiry conclude, determine the responsibility, and at that point in time we'll know the extent of the compensation bill, and at that point in time I think it'd be the right time to have the conversation about contributions for which they've already accepted moral responsibility, which we absolutely welcome. Can I just say, although the Post Office has had a checkered past in this regard, I believe it also has a very bright future. We should always keep that in mind. We're keen to make sure it does. The honourable friend, the member for East Antrim, talks. He absolutely quite understand what he says about the territorial extent of this. And I say before, I met with his First Minister and Deputy First Minister yesterday, and Justice Ministers will continue to do that. We're determined to make sure that this is brought forward as quickly as possible in all areas of the United Kingdom. He makes a very, very compelling case, and he talks about the need for public consultations, which we're aware of in his jurisdiction. There are 26 cases, I think I'm right in saying, in Northern Ireland. We're keen to make sure those cases are overturned as quickly as possible, and we'll continue the work to make sure that is the case. The honourable gentleman member for Orkney and Shetland talks very clearly about making sure that prosecutors are accountable for what their role in this, of course. Decisions were taken in Scotland, he's quite right to say that, and I think he said it quite clearly in his comments. The legislative consent motion does not offer the same level of parliamentary accountability, and I think that's something we should all reflect on. So, and I think his final words is accountability makes a difference. The honourable member for North Down talks about the UK-wide preference for this, which we understand. We've had several conversations, and we'll have many more, I'm sure. I understand the points he raised about the risk of JR and around the public consultation and the delays required in that. And I understand his points. He feels he makes an overwhelming argument, and we'll keep those conversations going. And can I finally just, in relation to the comments by the Shadow Minister, can I concur with her and echo her praise and pay tribute to people like Alan Bates and many other people, Joe Hamilton, Lee Castleton. We would not be here without those people. And many others, Nick Wallace, the journalist, Dan Needle, a campaigner in this area, Tom Witherow, and the journalist Lord Arbuthnot, of course, Carl Flinders, as well as many members of this House. And we pay tribute to the work they have done. It has taken, we recognise the profound impacts that the Horizon scandal has had on those who were falsely accused. The time taken to get to this point, it has taken too long, as our ambition is to get this legislation through the House, through both Houses by July, and compensation paid to those victims by August. Madam Deputy Speaker, through this bill, we will exonerate those who were so unjustly convicted of crimes which they did not commit, and provide fair redress as swiftly as possible. And I commend this bill to the House.
The question is that the bill be now read a second time. As many as are of that opinion say aye. Aye. The contrary, no. I think the ayes have it. The ayes have it. Programme motion to be moved formally.
I beg to move.
The question is, as on the order paper, as many as are of that opinion say aye.
Aye.
The contrary, no. I think the ayes have it. The ayes have it. Money resolution to be moved formally.
I beg to move.
The question is, as on the order paper, as many as are of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. The ayes have it. Thank you. Petition